Mastery and Commerce workshop sessions, here and after sessions, are the private exchange of ideas and concepts between the providers and recipients. The content is not meant as legal advice. Use or attempted use of any idea or procedure discussed in these sessions is applied to the recipient's own personal transactions, cases, or controversies, or applied to other cases may or may not result in a favorable outcome or the same outcome as discussed in these sessions. Each transaction, case, or controversy may be different as a result of unique actions or unique statements made by the parties therein, and each different act or statement in any transaction affects or may affect whether any procedure or idea discussed in these sessions is relevant to the recipient's transactions or whether the outcome thereof will be depicted as in these sessions. The discussion of ideas or procedures in these sessions is not exhaustive of the subjects being discussed. Many ideas and concepts that can affect the outcome of any legal or commercial procedure are not discussed in these sessions. In fact, the recipients may not be aware of these issues may have an adverse effect on the outcome of the recipient's procedures. It is the responsibility of the recipients to understand their own transactions and to apply the appropriate and complete concepts necessary for a procedure and substandard remedy thereto. These sessions may be redistributed privately by any recipient to another recipient requesting them, conditioned upon the fact that this notice is provided therewith. If you have any questions, you can contact Mastery and Commerce by email at info@masteryandcommerce.org.
I'm still confused as to the hats that you're wearing.
Yes.
And when and where.
Are we ready to go over hats? Let me think.
Let's do hats.
How many feel they need any more attention in split title, the basics of contract, offer acceptance? No? We're good? Split title, everyone got a handle on? You have a question about split title? Equitable title, legal title. What are you unclear about?
Each one of those titles has the beneficiary, the trustee.
Yes. In the split title system, the split title was created by trusts. Okay, now trusts have been around a long time. This isn't a new invention. Okay, in fact, as far back as you could track law, you could track trusts. As far back as you could track contract, you could track trusts. Okay? So the trust creates a split title situation. Okay? Without a trust, there's only one kind of title, it's notarial title. You either have title or you don't. Okay? As soon as the title is split, or as soon as a trust gets involved, the title gets split. There's legal title, which is control. Controlling interest over the property. The trustee has control over the property. That's the reason why you're driving down the street, they pull you over, you don't have a driver's license. They can take the car because it wasn't yours. There was a beneficial interest, equitable title, but control of the vehicle lied with the state. That's why they can take the car. Otherwise, if you had a notarial title to the car, could they take it? No, they have no right to it. But in this scenario, they have control over it. Equitable title is beneficial use. We often call this ownership. Okay? And we have in our society a built-in programming for pride of ownership. We all seek to be the owners of something. Owners of businesses, owners of property, owners of vehicles. And that pride of ownership is what gets you into all the trouble, gets you into the mess, because you're down here and you've given control to someone else. Okay? Now, we've described how with a contract you can obtain a controlling interest. So for instance, in John's scenario, LLCs own the car. Owning it means they have an equitable interest, equitable title to the car. But if that LLC had a contractual obligation to another entity, let's say to John himself, an LLC is a limited liability company. It's a type of corporation. Okay? If that corporation had a debt obligation to John himself, and the LLC owed John, let's say, 50 grand, and the car was 25 grand, okay? John would then file his interest with the DMV on the vehicle. Basically, I'm the lien holder. I have a $50,000 interest on that vehicle. So now John takes on the role of legal title holder because he has a lien controlling interest in the vehicle. So the LLC is still an owner, still equitable interest holder. But at any time, John, the legal title holder, could take the property away from the LLC. And if anyone else gets involved in the contract with the car, they have to answer to the lien holder, the person who controls the car. So nobody can really do anything with that car without John's permission. The LLC couldn't even really sell the car without John's permission.
Because he has a lien on it.
Because he has the lien on it.
Which gives him the legal title.
Let's say the LLC took the title to the DMV and says, I'm selling this car to Pete. And Pete's standing there, yeah, I'm here, I bought the car. And they sign the back, and Pete fills out his information as the new owner, and they give it to DMV. DMV's going to look at it, and they're going to go, I have to notify the lien holder. They notify the lien holder, and they go, sorry, we're not going to transfer this title. Because the lien holder told us no. You see?
So where's the title?
The title is split between the LLC, who has equitable title, and John, who has legal title, because he's the lien holder.
The title itself is only a registered claim. It's a claim check. It says somebody's got a claim.
And there's
It's a piece of paper?
There's multiple forms of title. Like, for instance, John's interest against the LLC could be registered on a UCC-1. That would be the equivalent of his title in the vehicle. That would show his controlling interest in the vehicle.
Well, understand.
Whereas the beneficial interest holder has what's called a certificate of title, which is like a certificate of beneficial interest.
The UCC is not the title. It is a public notice
Of
that
the title.
somebody's holding a security agreement, which is a claim or a title behind the scenes.
So his
and
contract-
that security agreement may not be filed, but it's a notice that exists.
So the contract between John and the LLC is the actual title, but that's private. Okay? So he registered his interest on the UCC-1. The UCC-1s and the UCC-3s don't do anything
Except give notice.
except give notice of what's being done in the private. So for instance, if like we use our UCCs when we issue different types of instruments like bonds, promissory notes, money orders, things like that. As the maker, I'm going to register my interest in the instrument. Okay? Now, is registering when I filled out that UCC-1, is that what gave me interest in the instrument? What gave me interest in the instrument? My signature on it. When I signed the instrument, making me the maker, that gave me my security interest that I register. I give notice on a UCC-1. Then I send the bond to, let's say, the Attorney General of the State of California to offset
a copy.
Let's say, a court claim. Okay? So I've sent this bond now to the Attorney General, and I register this assignment on a UCC-3. Is the UCC-3 filing the assignment?
No.
What was the assignment? When I mailed it and made the Attorney General the holder in due course. That was the actual assignment of interest. The UCC-3 just gave notice that the interest was assigned.
And
now, does that mean does that mean my interest went away? No, because my signature's still on the instrument, isn't it? So I've still got an interest, but I'm no longer the holder in due course. The Attorney General is now the holder in due course.
I'm still a little confused on the scenario with the legal title. When you purchase the car, you register with the state has legal title, you have equity title. You
Right.
transfer it or you exchange it into a trust, the trust has legal title. Now,
No, hold on. What are you transferring? Now this is key.
Yeah. I don't have a key.
Let's say in John's situation, where he has the lien on the car, let's say he transfers that into a trust.
the lien.
The lien itself. That now
Not
gives
the
the
owner of the
trust
title.
controlling interest over the car, doesn't it?
Is that legal title?
That's legal title.
Now, what about the state still has control, though, right?
It's got another form
It's
of
got a
legal
different
title.
form of
that's what I mean. It's
control.
like a three-way split title.
Right,
or
but
something?
because the state stays in the background, the state can only step forward when there's presumption of there is no legal title holder. That's the only time the state will step up and say, okay, we're going to manage this property, because we step into the role of trustee when it appears as if there is no other trustee. But if John steps up, the state's going to stay in the background because he's got a registered interest.
In essence, the state is filling a void because nobody else accepted responsibility.
I understand that, but
Anything done with the title. Okay, something that all lien holders must know is they need to register their interest on the property, right? So let's say it was real property. And let's say Jack had some real property. And the real property is worth $200,000. But Jack owes me, through contractual obligation, $500,000. And through a security agreement where we both agree that his $200,000 property is the security on that $500,000 debt he has to me, and I register that interest, that security agreement, on a UCC-1, and I file that UCC-1 in the county against his property, I'm now the legal title holder of his property.
But I'm still the owner possessing and using it until the legal title holder, there's a breach and he's coming after it.
And so Jack can't do really anything with that property.
Except stay on it, possess it, and use it.
If he tries to sell it, they're going to come to me. If the government, let's say Jack's not paying the property taxes, if they say, well, we're gonna take your house and sell it for the property taxes, well, guess what? Guess who gets paid first? I do, because I have a commercial lien on his property, which is a higher form of lien than a tax lien, and my lien predates the tax lien. So, and my interest is $500,000. So, what good would it be for the county to sell the property? What are they going to get out of it? Nothing. Not a dime.
So you're saying they probably wouldn't sell the property?
They wouldn't even touch it because they got to go through the lien holder. They got to go through me. Now, they may go through the process of giving notice that they're going to sell it, but who do they have to give notice to? Me. And if I don't assert my claim or my right to that property and I just stay silent, they'll sell it, get the tax money, and be done with it. Doesn't mean I can't come back later and say, hey, didn't you sell that property? Well, you saw my recorded interest, right? That predated your interest. Pay up. So I could go back to them later and collect. And I could kick out whoever's in there. Let's say they sold it to Ginger. And Ginger's now happily living in Jack's former house. But I've still got a UCC-1 on that property. And I come in and I go, oh, you're out. I'm selling this property because I have a $500,000 interest on this property. And she's going to be really upset because she paid the county $20,000 for it.
But she should have checked the records and seen that there was another lien.
Oh yeah, because believe me, the county wiped their hands clean of it because what did they give her, Jack? They gave her a notice of something.
Well, they gave her a colorable title. It said that as far as we're concerned, you've got our interest now.
But no guarantees as to any other interests.
But doesn't the county give you notice as a lien holder that the taxes are not paid, that you're supposed to pay the taxes?
No, I'm not necessarily supposed to pay the taxes because grant deed's in his name.
See, what might happen, remember, haven't we told you all contracts can morph? So what the county might do is they may go into a judicial proceedings in order to foreclose on the taxes. And their lawyers have done a study, so what they're going to do is they're going to name Brandon as a party of potential interest in this sale of the property. And so he's going to get service of summons, and the way the contract's going to be written with the court, if he doesn't come in and make his claim, they may claim he is forever quit claiming any interest he might have claimed if he does not come in and defend. So, with given notice
implied
and
contract
failure to appear,
my performance.
See, even though he's got a recorded interest, if he fails to come in and maintain his claim, the court may issue a judgment that says, well, we're just going to expunge his claim off the record because we gave him notice and opportunity. He failed to come in, assert his claim, so therefore he no longer has a claim. Now Ginger goes out and buys the property after the foreclosure based on taxes, and now she don't have to worry about that because they're going to take it off the books record because he presumably consented when he failed to appear and assert his claim.
So you're saying if he shows up in court,
that's different.
Shows up in court and says, I have a claim on this property.
And then they may say, prove your claim.
Okay, UCC1, UCC3.
That's just notice.
Yep. I could bring my contract into chambers because it's a private contract, and it would and I have it's proprietary information contained within the contract, so I would bring in the record into chambers because that's where the judge can see substance anyways. I would bring my records, my UCC1, into the case because I'm going to file a pleading on the public side. And my pleading on the public side is going to be supported by a record. And that record is the UCC1. But in it, I'm also going to mention that there's a sealed record in chambers, and I'm going to tell the court to take judicial notice of it, to open the sealed record and take judicial notice of that record which supports the filing of the UCC1.
So you're saying you could essentially wipe out property taxes in a sense?
Well, that's not really wiping them out.
They would always
Tax still got the debt and obligation. It's just no longer secured by the property because I'm in the way. So they can't sell the. It doesn't mean that the property tax isn't going to keep going up.
But you understand, if Brandon's going to be the ultimate creditor, what he may end up doing is he may end up coming into the court. He may not even assert what his actual claim is. He may be the accommodation party for Smith, the tax cheat, and he may pay the taxes just to wipe out the county's interest.
Because that's in my interest. Because if there's any other encumbrances on the property, that infringes on my claim to the property.
Because if he gets the property and tries to sell it, somebody else may have a claim like the county.
Right. Exactly.
Now, does the commercial lien have to predate, say, a mortgage lien or tax lien?
First in time, first in line.
First in time, first in line is the general rule. Now, there is a hierarchy to liens.
There's priority claims, like sometimes of government, whatever.
Like, for instance, you know, the example you were just using with the tax, let's say the property tax.
Property tax, okay.
When the property tax is overdue, the county may notify the lien holder, the bank, if there's a deed of trust, that the property tax is overdue. What's the bank going to do? They're going to pay it. You know why? Because they're below, even though their claim is dated back to the deed of trust, a deed of trust, which is a mortgage lien, is lower on the food chain than a tax lien. Okay, so this is basic order of liens in priority. First, on top, in paramount interest, is a commercial lien. Then next below that, you have your tax liens. Then you have what are known as, what are the contractor liens called?
Mechanical lien.
Mechanics lien.
Yeah.
Where does the federal lien?
Tax. Right here. Same level as tax. Mechanics lien.
How about a hospital bill?
Oh, hospital bill is going to be probably a mechanics lien. And then you have mortgage lien. I feel like I'm leaving one out here. Isn't there 5? Mortgage lien, tax lien, commercial lien. Oh, well. A what? Where would that fall? I'm going to call that, yeah, but what is that? What would that be called? Because it's not a mechanics lien. I would say it's just I don't want to call it a credit lien. What would we call that? Like HELOC interest. It's actually secured, but it's at the bottom of the food chain, and I used to have this down. If you guys go back to about 2007 and listen to the Living Temple, I actually prepared myself for this talk and gave you all 5 forms. I forgot what the 5th one is called, but it'd be the equivalent of like a HELOC or any kind of a credit lien would fall behind the mortgage lien.
Randy, I bought a lot of tax properties in my life, so when I was with some tax sales, they would remove all tax liens except for the federal. They could not take, could not get rid of
federal. In this tax lien category, federal would be above state, because we're in the democracy, everything's upside down. Whereas in the republic, it goes people, state, United States, or people, county, state, United States. In the democracy, it goes United States, state, county, people. So it's an inversion.
Brandon,
so I'll just call it a credit lien for lack of a better term.
I have a scenario. Say a corporation that I, the live person, controls this corporation, and that corporation has a property, and that property has a tax lien.
Because of the corporation's tax obligation.
Someone bought the taxes. They haven't foreclosed yet, but say a company bought the tax, and the county has a tax lien. So there's two.
So there was a tax lien on the property.
Yep.
And there was a mortgage lien on the property.
No mortgage lien.
Okay.
It's just that the county is holding a portion of the lien property for the property taxes, and another company bought a certain year, say 2007, 2008.
So they bought part of the county's interest.
Part of the county's interest. So, as a creditor, what would you do in a situation like that to get a allodial title?
You've got, allodial title is a different question, but you've got 2 parties in order to discharge on that property.
Okay.
Because you've got, the county is still holding a tax lien.
Yep.
And there's been an assignment of a portion of that tax lien to another party. So you've got 2 parties that have a lien on the property. So if you want to free it of all encumbrances, which isn't necessarily getting a allodial title, but if you want to free it of all encumbrances, you're going to remove both liens.
By doing a private
set-off.
Private set-off. Okay.
A set-off. Yeah, doing a set-off with each lien holder.
Okay.
You want to make sure that any time, especially when you're dealing with property secured by debt, that you're addressing all parties of interest. Okay? So there's going to be parties of interest that may be the state, parties of interest that may be IRS, federal government. There may be parties of interest that include deed of trust holders, HELOC or line of credit holders, things like that. So if there could be at any one time 4 or 5 lien holders on one piece of property.
Gotcha.
And you want to, if you're looking to free all the encumbrances, you're going to want to address all of them individually.
And then once you do that, once you free and set them off, would you then do a UCC 1 or something on the property?
What are you trying to achieve?
Just protecting it.
Okay, protecting it would be getting that commercial lien in place. Now, it'd be best that whoever the equitable title holder is in a contractual relationship where another party has the controlling interest in it.
In this case,
like for instance, they're not going to buy into you being in debt to yourself, and therefore you have your lien holder and equitable title holder. Okay, that's a farce. Okay. But if there's 2 different parties,
like a corporation,
right? Like let's say a corporation, an LLC, or a trust has an if you are, when I say you, I mean your strawman, is the actual, let's say, grant deed holder, and you have a debt to this other party that's, let's say, 3 times the amount of the house, and that party uses the house in a security agreement with you as collateral on that debt, and then registers its interest on the UCC and files that at the county. Well, now there's a legal title and an equitable title of record. Okay? And that trust, corporation, LLC, whatever it is, has the controlling interest of that property. Is it an agricultural lien? Is it the fifth one? Oh, agricultural lien. No, I think agricultural lien falls into commercial lien category. Yeah, it doesn't belong on here, I don't think. Agricultural lien is one of the highest forms of lien, and I believe it would fall into, because it deals with the land, and as soon as you start getting into tax lien down, you're talking about franchise or statute forms of lien. And an agricultural lien, because it's on the land, you're kind of outside of the world of legislative entities, because legislative entities don't have any claim to land.
Can you explain the difference between a commercial lien and mechanics lien? And the reason I'm a little confused is because I have a friend of mine who did some landscaping work, and I told him I was going to charge him $5,000 an hour, right. And he agreed.
But see, he operates his landscaping business under the protection of the franchise of the United States.
No. I just did I have no franchise or anything. Just me as private entity. Like,
how were you paid?
I have not gotten paid yet.
Okay. How did you contract?
Well, I told him this would be $5,000 an hour, and I haven't really specified.
$5,000 an hour for landscaping work? Yeah. Damn, he needs to find a better landscaper. Or, I mean, a more affordable one. You may be the best. If you're charging $5,000 an hour, you must be damn good at what you do.
They're going to presume you're doing business as a proprietor.
As a franchise.
Under Schedule C, under the fiction of your straw man, which is under the corporate United States.
Okay, then what about $5,000 in gold per hour?
Okay, now if you had a contract and had a record of that contract where you stipulated just as simple as the governing law of this contract shall be private international law. Let's say you had that clause in the contract, or that the parties entering this contract do so waiving all rights, all benefits, privileges of any and all franchises, including the United States, the state of California, whatever, right? So what you're doing is you're building into your contract distinctions that I'm not operating under a franchise. Because if that distinction isn't there, then the presumption is you're operating under a franchise. Because the property itself is within the United States, because it's got a taxable parcel. And that taxable parcel is registered with the county. The county is a political subdivision of the United States. So it assumes that the contract falls under the franchise, so it would be a mechanics lien.
Because there were improvements on it. But the improvements is not to the dirt and the soil. The improvements is to what is created on the dirt and the soil.
It's the value on the taxable parcel.
Taxes never are on the dirt and the soil. They're on the improvements.
Okay, so now the same scenario, if you had an express contract whereby you were establishing the jurisdiction and the venue of the contract, it could be a commercial lien. But you'd also have to be doing it for, like you said, gold or silver. Because again, you've used Federal Reserve notes in that contract, and now there's the presumption and assumption that it's a franchise. Even though, if you look at the Federal Reserve note, it says that it's good for all debts, right? Private and public.
But it's only good as a tender.
It's only good as a tender.
Which
what does that mean?
Payment.
Okay? So, it's very important when you write a contract, and again, this is something that we'll go into more as the weekend goes by, and we'll actually show you example contracts that we use these clauses and terms in to distinctly set the jurisdiction and the venue for where the contract is happening. But again, when it comes to enforcement and you're going to be in a court, can you hold it? So you not only have to have these clauses within the expressed contract, but you must know what it means so that you can keep it there. Because if somebody challenges your commercial lien and says, well, he just did landscaping work, That's a mechanic's lien. So now they're arguing, right? What are you going to do? Are you going to argue back? Yeah, if you argue back, you've lost it. But can you stand on the original contract? And can you enforce the original contract?
Can I get a sample of the clause?
Of the clause? Well, I just gave you a sample of a couple clauses.
You kind of like write it down, everything there that you say.
Oh, you want to write it down as a
contract? Yes.
Okay. Go back to the audio. And I'll show it to you on the screen. Okay. It's either tomorrow or Sunday. I'll show it to you on the screen. Because it'll be much better. I take a lot more time with the stuff I write than the stuff I just spit off the top of my head. So you'll get better quality off of what I show you on the screen than what I just spit out of my mouth right now. Because I put a lot of thought into what I write on a paper. I put a lot of thought into it. Don't I, Jack?
He's a better performer than he is an actor.
Yes, definitely. I can what's the word? Produce music, but I am horrible at playing music live. But I can produce some really good music. But I treat music like a science. And so I can program the music and write the music and make the music. But if you got me up here with a piano, I'm going to suck. And you guys are going, oh my God, stop, please. So that's what, for me, what's on the contract has taken a different level of understanding and work than what it takes to hold the contract. What it takes to hold the contract isn't as meticulous. It takes more, it's more about a way of being. For instance, especially if you're in court. Because in court, if you're in a fight or flight mode, you're going to be horrible. You're going to do horrible. And you're going to argue, and you're going to make statements, and you're just going to dig the hole deeper and deeper and deeper, and you're going to lose your contract. So it's about a presence of mind and about a state of being, of calm, humble, so that you can hear what's being said, be present to it, and turn the contract back to the terms and conditions that you agree with. You know, so, and you guys have heard of conditional acceptances, right? What is a conditional acceptance? It's a negotiation. It's counteroffer, right? So I conditionally accept that upon these terms. However, you've also got something that I coach people on is not only do you have to be mindful of when they're making these offers, if you don't respond to them, you're in acceptance, right? Because we can't presume refusal. And if you're not saying anything, clearly there's no counteroffer. The only thing we can presume is acceptance. Okay, now this is a maxim of law. That if one goes silent, the presumption is acceptance. Unless there's an obligation to answer, which then the presumption is fraud. Okay? So,
let me give you an example of that in a criminal court. Okay? Very easy. The first time you go into a criminal court is usually called the arraignment. It's a presentment. And presentment of a claim is under UCC 3-501, subprin A, subprin little I. And what it is the party that is entitled to enforce an instrument has to give notice of their claim. Well, what is the interest or the instrument in a criminal case that's being enforced? It's the charging instrument, whatever it is. It could be a criminal complaint, could be an indictment, could be an information, which is a complaint signed by a prosecutor, or whatever it is, okay? So, who is it that's holding that instrument in the criminal court case? Usually it's the clerk of the court holding the original charging instrument in the court case file. Now they play games today because now with the new electronic commerce, You go to the clerk of the court and say, I want to see the charging instrument with the original signature. And the usual answer is going to be, well, here it is in the computer. I'll show you on the screen. And you go, no. I need to inspect the original instrument with the blue ink signature. Well, sir, you see, we don't have those anymore because the new laws permit us to put it into electronics, and that's all we have. Now, chances are they're blowing smoke, but we don't want to get into an argument. Let's get back on point. They're giving you notice of what the charges are. Now, when the judge is talking to you, he's saying, do you have a copy of the charges? What he's really doing is saying, look, in order to proceed in a commercial debt collection case, we have to give you notice of what it is that you're here for. Have you received notice? And what is the typical answer to that? Yes, Your Honor, I have received a copy of the charges. Now, you may be asking for the original, and under 3501A sub paren I, you've got the right to do that. But you're going to create some arguments because they're going to up and down tell you, no, we haven't got it anymore. Then they will tell you that the copy is as good as the original. That's both true and false. If you get a copy of your straw man's paycheck, can you go cash it? No. So, the fact that you haven't inspected the original limits your ability to resolve this case. Because if you could get the original with the blue ink signature, what do you need to do to resolve the case? Turn it over on the back and endorse it, because the charging instrument is a negotiable instrument. That's all it is. It's a request for a sum of money due, right? And if you endorse your paycheck, can't they put it into the bank for collection? So if you endorse the charging instrument, they can put it in for collection, set off the accounting, and everybody goes home. But wait a minute. Then you would really understand that the criminal courts are only there to collect a sum of money due. And then after that, everybody would go out and they'd commit bank robberies and they'd kill each other and do everything else, because all I got to do is take the pen out of my pocket and sign the charging instrument and I get to go home. So believe me, it's going to be a test beyond just doing that. But let's stay on point. The offer is, have you received a copy of the charges? The answer is, you betcha. Second question, do you understand the charges? What is the judge asking you there? Reverse the words. Do you stand under the charges? What is he really saying? Will you come into our jurisdiction and pay them? Or stand under means will you be responsible for this debt? That's what he's asking you. It's not mentally, do you understand or comprehend the words we're saying on this piece of paper? There's nothing to do with it. Are you willing to be the creditor or the accommodation party and pay this thing off? That's the second question. The third question is, how do you plead, guilty or not guilty? Now there's other offers that are unstated, but guilty comes from the German Gilden, and Gilden is money. So when he says, do you plead Gilden or do you plead not Gilden, he's asking you, are you going to pay? So the three questions: have you got a copy of the bill? Are you going to pay the bill? And are you going to pay it today? Or are you going to object to payment? That's what's going on. So, what is the perfect counter offer to this? You can come in even before the arraignment in writing, and as the accommodation party, you can literally say, I not only have knowledge of what the bill is, I got a certified copy. Why would you get a certified copy? Is it not a record of the tender offer? So that they can't say, well, where the hell did you get that offer? That's not what we offered. And they're trying to change the contract. Since you got a certified copy, at least at one time out of the clerk, holding the instrument that needs to be discharged, you've got a record of agreement. This was your official offer as far as the clerk is concerned on this day. So now you've got a record of the bill that you're talking about. Secondly, you say, I agree as an accommodation party to stand under it. That means you're a creditor, you're responsible. Then the third thing you say, and tendered herewith, is the set-off instrument for full payment. Have a nice day. Haven't you, before you even have the first appearance in the court, aren't you in perfect harmony with these people? And what's the judge going to say by time you come into the appearance? He's going to say, well, you got to be here anyway to settle this. Okay, I'm going to conditionally accept that hearing and proof of claim that my purpose as the accommodation party coming to the arraignment is not merely to stand behind my counteroffer for acceptance by the court to do one of three things. To take my tender of payment and to use it to set off the accounting against the defendant. Number two, to have this court close the case. And three, have this court release any liens or levies or claims upon any of the property or collateral of the defendant. And we've solved the case before we've even started the case. That's my counteroffer. That's what I'm sticking to. You see the power of counteroffer and not going in and arguing with these people.
And so if there's no response to your conditional acceptance and you show up, what are the terms that you're there showing up under? Exactly. Discharge of claims, acceptance of the tender. What else?
We want to close the case. We don't want the case dismissed. Because to dismiss a case, it isn't there and everything you've done is of no effect and you're asking them to give up their claim. We don't want them to give up the claim. We want to do it.
Think about this. If I've got a private settlement contract, the public case can be dismissed because we've settled in private.
Could be. But remember, if we've used a set-off payment from the asset account, when can they apply that to the case? Not after they dismiss it, but if they close the case, account that's closed no longer can be added to and subtracted from on the public, but nevertheless it remains open for set-off settlements and agreements in the private. So we're saying close your case and apply the set-off and everybody's a happy puppy.
So we've seen it happen. Where am I? We've seen it happen both ways, where we've done our private settlement, we've gone in and gotten dismissal based on the private settlement, and we've seen termination. So it can go either way. I guess it depends on how you're moving it on the public side.
And what's the definition of termination?
Closing. It's both. It's when both parties agree.
It settles a contract.
It's
and
settlement
party
when
is
both
prejudiced,
parties agree.
So everybody's a win.
Yeah, that's termination.
You mentioned it about the charges requesting for the original documents, and after that, you requested to endorse that. How are you going to endorse it? It's like a challenge.
Just like a check.
Like a challenging the judge, say, hey, I need to get original document and I need to endorse this. How are you going to do that?
I don't know if I would say it like that.
Not in the way. In the way, it's like you're saying it like that.
Here's the answer to that question. See, we have been attempting to go after the original charging instrument, and it is amazing how many times our people have gotten that. Both in bank foreclosures, because even though they claim the note is history, the note isn't history. If you had something of value, why would you go out and destroy it? They just want you to believe that they destroyed it. You're going to find out that the only reason that you're in a foreclosure is you never endorsed the original mortgage note. And it doesn't mean you can't do it now. If you get them to cough it up and you're inspecting it, take out your pen and endorse the back of that note right now. because as soon as you endorse it, they can take it back to the window and they can process it. And the reason the bank is foreclosing on you is because a VP of the bank had to endorse your note when you did not. So the bank is liable on the repayment of the money. You're not liable, and they're suing you either through the trustee or through the judicial system because you forced them to be liable on the currency that came out of your asset account because you didn't endorse that note. If you endorse it now, they can go back and get the currency on your buck, apply it to the liability they've got, zeroing it out, and then their claim is toast. But if you can't get that original instrument under 3-501 subparen A, subparen I, it's got your remedy under 3501 subparen A, subparen II, which says that all you got to do is make a new note and tender it to the bank, and the new note discharges the original note without having to get your blue ink endorsement on the original note. So whether or not they produce the original note is immaterially irrelevant. Just create another one and give them the second one.
Now what's interesting is we're floating through different scenarios here. We've just floated from criminal to mortgage, right? But it's all the same thing. It's all commercial. Where's the original instrument? Without an original instrument, there is no claim. So if the court cannot produce an original charging instrument, there's no claim. And we've had clients who have been successful in saying, well, if there is no original charging instrument here for my inspection, then my business here is concluded. Thank you very much. And walk out.
Yeah, but what I've seen before, I getting into the court before, and I look at the cases many times, especially on a criminal case. And what I've seen is if it's somebody challenged the judge saying, hey, I need to have the original document, the judge is going to say, hey, you know what? It's like...
You never say that. Did you hear me say, I need it, and you need to give it to me? It is very much about how you are being in the transaction as to what kind of a remedy and results you're going to create.
Yeah.
Okay? Really what's happening there is an argument. Okay? You don't want to argue with the judge. Okay? What you're doing is you're going to make an offer. Okay? Because we can't force anything upon anyone. If that were the case, this would be a very miserable world. It's all by consent. Both ways. It's not just it works for you, but not for everyone else. So it's by his consent too. It's a contract. But I'm going to spell out the terms. That if you can't produce an original charging instrument, then you have no claim. My business here is complete. I'm out. Or if you're incarcerated at the time, I demand to be set free. If there's no claim here for me to inspect, I demand to be set free immediately and that this case be closed.
Can you do that?
Yes. And we've had people have success with it. We've had people who have had success with it who've been charged with felony crimes. And they've been escorted from the premises.
Well, that's kind of like new.
Now, again, it's all about how you're being in the scenario. What's the judge doing? Because you could have all the paperwork perfect. You've done all the perfect paperwork. Or you don't have to have a single piece of paper. You can get your remedy either way. But it's going to take that test in the open market of the court to get you what your remedy. So it's all about how you're being. If you're being confrontational, argumentative, angry, righteous, you're not going to get your remedy.
Think of your paperwork as a resume and you're out looking for a job. It doesn't mean that if you didn't have a resume, you're never going to get a job.
Right.
The purpose of the resume is like your calling card. It's like your invitation to come to the party. And if it's unique and interesting, your likelihood of getting an interview goes up. But the interview is the test. And you can have a perfect resume, but if in the interview you really suck.
Yeah, if you show to be that you're totally incompetent, because your resume could say, yeah, I've got all the skills of an electrical engineer, and I've got 30 years of history as an electrical engineer, and yet they start asking you very basic questions about electrical engineering, and you have no idea. You've shown yourself to be incompetent. Are we going to hire you based on the resume? Hell no. Because in the practical examination, in the interview, you showed to be incompetent. Now, what I've noticed with my paperwork when I get in front of a judge is judges are very interested to see where I go. They're paying attention. Okay? So that's what I've noticed. What my resume gets me is an interested interviewer. But it doesn't get me the remedy. The paperwork doesn't ever get you the remedy. If it did, we'd be in a lot of trouble. Think about it. Do we really want a document to get people their remedy? Like Jack said, you'd have people pillaging and murdering all over the place. And, oh, well, I got the magic piece of paper. It's going to get me out of jail for free every time. Right? We don't want that.
That's why Brandon and Gordon and I keep saying to the people that come to us with assistance, we'll help you get a contract if you can keep it. And we have to spend a lot of time with the people we're helping to show them how to keep that contract, because it's on our clients to win their case. It's not up to us to win their case. We're just helping them understand the factors that are involved. We may help them prepare some really neat resumes to work their way through their case. But they've got to go in and they've got to work the paperwork, or else it's not going to happen.
And we've seen it. We've seen people who really take on the studying and learning from our coaching, and they get the success. People with the perfect paperwork who don't take the time and the coaching and the studying and keeping the contract don't get anything. We've seen two people in the same case. One had believed it. For one, you have to believe you are the author of your life and you are the authority. If you don't believe that, there's no reason for you to be there. You're a subject. Do what a good subject does. Obeys, right? But if you do know in your heart that you are the authority, then this can work for you. If you don't know that in your heart, you're not going to get the success. And what's funny is we've even seen people get the success who didn't have that in their heart and still doubt it. They've got the success. Over and over and over again they've had successes. And yet they still don't believe in their authority. They still don't see it.
But sometimes those people 3 and 6 months later are brought back into the trial again, and then they fail.
Yeah, no, but that's why it happens over and over and over again. These are people who don't have it in their heart. So, and somebody on the other side knows this, whether it's the prosecutor, somebody knows that it's that there's Jack and Gordon in the background, right? They know someone's in the background. We know if we keep testing this guy, we're going to get him.
In fact,
because eventually
we know that so well that if you're in a criminal case and you're in jail and you're calling us, aren't they recording the calls?
Oh yeah,
absolutely.
They know.
And do Gordon and I care? Absolutely not, because we're there to help the client. And like we consistently keep saying, these people in this court system are here to help you. And we've had some of our clients that we prepared for a hearing. They go into the hearing, they come out of the hearing, they're still in custody, and they go, well, that didn't work, that sucks. And we said, well, what happens? And we've had 1 or 2 instances where even the judge in the open court hearing made comment about what we were talking about on the telephone and kind of fatherly saying to the client, well, why didn't you do this? And it's exactly what we told them to do on the phone. These guys are waiting to see if you can understand it and get it.
I'm telling you, the way I see it now, because what we've seen happening in the courts is evidence for me that this is a partnership. That myself, Jack and Gordon, are in partnership with the judges. We're in no way adversaries to them. It's a full-on partnership. We may assist people with the preparation of the documents, and we may coach them on how to be in the courtroom, but ultimately it's the judge who's stepping in for us to test, is this truly a responsible person?
We are the mirror image to the legal system in public. They will torn them back into the public if they can't understand their private rights and remedies. But the judge is not. You know how on the telephone calls for prisons they say, oh, we have the right to cut off this call if. And they got all kinds of reasons. Most of the time they never cut off the calls to us. You know, they've got this rule, well, no third-party calls are permitted. And they got Gordon on the line, they got me on the line, they got the family members on the line, they got the priest on the line, and Satan and everybody else, and they're just letting us talk. So it's not what is happening, it's the way it's happening. We're trying to put common sense into these people's minds so they can go in there and solve their problem and the state problem. And sometimes they get it, and sometimes they don't.
And the judges are the perfect gatekeepers. The way I see it, I don't think we've ever seen a judge do it wrong.
No.
They never do it wrong. So for us, it's perfect. And I feel like we're at the dawn of something big. That if people really get this in their hearts, their responsibility and their authority, that we can radically transform the world. And the judges want that. They don't want a democracy that ends in anarchy. They want to see people being responsible and stepping up into the republic. And so they're cheering us on. And at the same time being the gatekeepers to make sure no one who is being irresponsible debtors gets through.
I was just going to let you know that her ex was a judge, and so I've been trying to introduce her into this world. Unfortunately, he's passed away, so she can't go to him and confirm it.
Right.
So I'm here this weekend. Hopefully, you'll validate it for her.
Oh, yeah. Well, judges are our best friends. That's how I see it. Because the judges are the gatekeepers. They're the ones standing there making sure that the contract is upheld and enforced. And they're always going to step in for the incompetence, and especially when it's on the attorney's side. Because I've seen attorneys and they're completely incompetent, but the judge isn't there. He's there to protect the public. So even if you've got the best argument in the world and you're beating the hell out of the other attorney, he's not going to necessarily give you the win. He'll step in for that other attorney and make sure that what's in the best interest for the public happens. So what's in the best interest for the public is for you to be responsible, is for you to settle your own problems, is for you to be graceful, humble, kind, compassionate, understanding. So that's what he's looking for. Are you a contribution? Or are you a liability? If you're a contribution, perfect. That's the kind of people we need in this world. So it's never going to be the paperwork. Very rarely have I seen paperwork get somebody a remedy, especially in a court case kind of situation. In civil cases, I've seen it happen, but never in a criminal case. I've never seen it happen in a criminal case. There's always going to be the test. Any other questions? Move on.
When you go into a court and what's the test exactly? Your interaction to see your capacity in the court?
It's open contracting. So it's going to depend on, first of all, when you're in a hearing, what was the last thing filed in the case? That's what we're here on today. Okay? So that's one part of the contract. So it's either an offer that has been made by the other side, or it's a counteroffer that you've put in, but it's something. Okay? So there's already a contract we're here to negotiate. Okay? Now, Now,
So even if you go the first time and you have the capacity to settle it and disclose it right then and there,
right,
the judge might still postpone it for another time.
Well, and there's a show to put on. Okay?
I'm sorry?
There's a show.
They have to entertain the public.
There's a show to put on. So, for instance, you're not going to get a remedy by walking into open court and saying, "Oh, well, I'm here to pay the criminal charges off." Not going to get you your remedy. It's not very.
He's just going to keep pounding.
It's not very colorable. Well, for one, they call it criminal. So as far as they're concerned, nobody can pay off criminal charges, right? That'd be bribery, right? So they're not going to, in open court, you have a conversation where you're talking about, I'm setting off the debt of the charges in this case. Okay? That happens in the background. That happens behind the scenes. Okay? The original charging instrument conversation, that can happen in the courtroom, but in reality, you're always moving it colorably. If there is no claim here, then I demand to be set free. Whatever your situation or scenario is, you're going to be moving the contract. Because if you're there in a criminal matter and we're at an arraignment, plead guilty to the facts. If you're pleading guilty to the facts under conditions, under the condition there's no jail time, under the condition that there's no probation or supervised release.
There's no complete public fines or fees due by the defendant.
Or that all fines and fees
so it's not what you say, it's what you
private
do.
Asset funds.
So if I'm here, let's say you're the judge and I'm the defendant, my person's the defendant, and we're having the interaction to see the capacity, and you're saying, do you plead guilty? And then I say, sure, I plead guilty, but I'd like to be...
I plead guilty to the facts under these conditions.
You're making a counter offer.
Now, he may say something else to test your competency. Is this just something you heard from Jack on the phone? You see what I'm saying? He may test you because, again, just like a piece of paper, if everyone could get the remedy from a piece of paper, our society would be a mess. Well, same thing that if everyone could get the remedy by just parroting a statement. This is what we mean by keeping your contract. The judge may say something like, "No, you can't do that. You can't set conditions to your plea." Then what? If you stand there silent, what just happened?
I accept your offer.
You accepted his counteroffer.
If you could show me that it's not the truth.
I conditionally accept.
I cannot set conditions on proof of claim that you have the right to refuse me unalienable right to contract.
Now, do I have to talk in this fashion? Because I can't always come up with that.
No, it's about the principles and the concepts. Again, if it were about parroting...
I can, but...
If it were about parroting a certain set of statements, you'd lose every time. You have to be able to be present, because we don't know what the judges will say. I mean, they've surprised us on several occasions, where they'll just say something randomly out of the blue. Yeah, it gets our guy kind of behind the eight ball, so to speak. He kind of falls back on the contract. But it's just an opportunity to renegotiate it again.
We actually had a judge say to one of our people that went in there, if you say conditional acceptance one more time, I'm going to have you taken out and shot for treason. How are you going to respond to that one?
I accept the offer.
Don't repeat the words conditional acceptance again.
Because conditional acceptance is the same as saying if.
Yeah, say...
It's that simple. If you say this or if you do this, then I will do this. That's a conditional acceptance.
But in that situation, though, if you went ahead and said, I conditionally accept again, what did you do?
There was an offer. I don't know. I think there was probably... I'm hoping that the judge was kidding in some way, shape, or form.
I think the judge did that because this guy just kept repeating the same mantra over and over and over again. The judge could have come back and said, what do you want for lunch this afternoon? Well, I conditionally accept that I'm not yet, and it has nothing to do with the new sentence, you see?
On a practical level, what could the judge then do?
The judge was trying to unlock his idiot. The guy was stuck in idiot. Okay, and the judge was like, hey, say that again and I'm going to shoot you. Like maybe the guy will wake up to being present here now in this moment and stop saying the same shit over and over again.
Being in honor, he was in honor.
He wasn't answering the question.
He wasn't in honor.
That was posed.
He wasn't in honor. He was just repeating a mantra.
Business.
Did he win?
Did he win?
He didn't get shot.
Go ahead.
So if I have a case and I get an unconditional discharge in the case, isn't that winning the case?
It's a win.
Yeah.
It's a win.
Yeah.
All right.
Yeah, in regard to his question that if you're in court, it's a commercial matter, whether it's criminal or civil. In a commercial matter, there's only one of two things that's the bottom line for that court case. Either a sum of money due is owed to someone, or performance on a contract is due and owing. So they're looking for you to agree to carry out the performance, to purge the contempt of not having done what you should have done to begin with, or a sum of money due is owing. So like I posed before, in the criminal case, you can literally, the judge is trying to say, did you get a copy of the bill? Are you going to be responsible, and are you going to pay it? It's so simple just to come into the court and say, Your Honor, we don't even have to hold this arraignment today. I understand that there is an obligation. I'm responsible for it, and I'm going to pay it. But like Brandon says, you are way too intelligent and smart and real. The courts are there for dumb, stupid slaves on the plantation. And the dumb, stupid slaves on the plantation do not have the capacity to pay the debt. They don't care about to pay the debt. They just want to go back and get their benefits. And so we've got to carry on a show here, because everybody behind the guy that's competent is totally incompetent. And as soon as you come in there and say, Judge, I got the invoice, I'm going to be responsible, and here's the payment, and the judge goes, bless you, my son, go your way in peace. Those 15 felonies and life in prison are gone. What is the next guy going to do when he comes up in front of the judge? Hey, man, whatever that guy did, I'm doing the same thing.
Right. He's going to parrot it. And that's why the judges are there. They're the gatekeepers. Because we had a success, the other day where the guy pleaded guilty under conditions, right? Now, if everyone in the courtroom came up and did the same thing, and the judge just boom, boom, boom.
That's called a plea bargain, and that's what they want. But they want it on their public terms if you're incompetent. You're just mirror imaging and putting it on the private terms because you are competent.
And that's why the resume in that case would have helped. Because it was clear it would have been clear to the judge that, okay, all these other guys aren't necessarily competent, didn't get their resume. But this guy got the resume. I was impressed. And then I was impressed with how he handled himself, because it mirrored his process. He's in honor. He showed honorable behavior by pleading, by accepting responsibility and paying, that he understands this. And it perfectly mirrors what I have here in front of me. You see what I'm saying? Now the judge may still test him and make a statement. And at that point, it's up to our hero to bring the contract back to his terms and conditions.
And what might happen in that court proceeding for the day, one of two things. The hero is going to be made to go first to put the pressure of an audience on him to see if he's going to perform. And if he starts out doing it right, the judge may go, hold that thought. Let me say, we're going to put this matter in abeyance till later. Sir, would you mind going to sit down right now? Let me take care of the sheeple first. So that he can see, the judge can see he knows what he's doing, and he doesn't want this guy, competent guy, putting on a performance in front of the sheeple. So he's going to take all these other debtors, get rid of them, They're outside the court. He's going to bring the creditor back up with a smile on his face. Now proceed, sir. I like what you were saying. What is it that you're bringing to the court today to see if he can perform? So now there's going to be no audience or no public witnesses to what's going back and forth in this court.
What's interesting, a friend of mine had done some paperwork on a case. This was a civil matter, and he did it all private, gave the judge notice and everything, and he comes into the court, and they saved him for last. They took a recess. When they came back, the California flag and the U.S. flag no longer had gold fringes on them. In fact, they were brand new out of the box, were still all creased up. They had hung new flags for him to have his hearing. Isn't that interesting?
So, all right.
But he'd already appeared in front of this judge several times before, so he had already had practical exams. So they already knew what they were dealing with. And they just wanted to properly honor him by taking it out of a military tribunal.
So say I have, or my straw man in the past had a criminal history. And then I did a couple of things, and all of those things were dismissed. And it's no longer
recorded. Were they discharged, though, in addition to being dismissed? Did you set them off with the equivalent of asset funds?
Well, yes.
Okay.
Well, then they're probably off the public books and records. You own them. They do not. Okay, go ahead.
Did you have any other question?
No, that was actually the question, because I did do this process a little while back, and I did it on my straw man's previous criminal history, which was years, and they're all dismissed now. So when I got into something else with a new case, and the judge asked if he has any prior criminal history, the district attorney was saying no.
Because it's no longer on their books. They don't own it.
Okay.
Yeah. But see, if you just went to jail, or if you just paid your fine with Federal Reserve notes, that's public service. And that's not a termination of the case. It's a closing of the case, but it's still there for collection because you only promised to pay, you never delivered. So that's the difference.
What about in a situation where someone's incarcerated in a penitentiary, and from what I understand, the minimus is that contract that holds them there? How would one get hold of that contract to do a private set-off?
Okay, understand, if somebody is in prison or jail, the body is your currency.
That's
because your signature is the ability to write the termination or the set-off of the debt. And we said that every judgment in civil or criminal is payable by a sum of money due. And the problem is if you are playing the role of the straw man debtor, you don't have enough money to pay off the multi-million-dollar claim of the felonies. So what they need to do is they need to get the money to zero the account from somewhere. So what they do is, since you are the money, they put you on deposit. I mean, they put you in prison. And the deposit of the money is ordinarily called a bank, right? But they don't call the prison or the jail a bank. But in reality, the prison and the jail is a bank because you're the currency and you're on deposit. Now, when you put a deposit of currency in a bank, can't the bank invest it and make money? Okay, so what's happening with you when they sentence you to 20 years? You're like a certificate of deposit. You're on deposit for 20 years. And
that's the contract that you're talking about, is the sentencing on the judgment.
Okay. Yeah, nobody can withdraw the deposit until the terms of the contract, 20 years, are up. So what they're doing is they're making a return on an investment for everyone in jail and prison. And who is the money going to? Well, it's split a number of ways. Part of it is split to the legal judicial system. Part of it is split to the prison that is keeping you upkeep while you're there. And then part of those funds are going back to compensate whoever was the winner in the court case that had the debt. So it's the corporate United States, the corporate state, the corporate county, or whatever it is. Now, everybody thinks, well, how much money can they be making off of a prisoner? Because he's going to work in the prison for 10 cents an hour. That's chicken feed. Your estate, your account, your birth certificate is worth a lot of money. And it's invested constantly on Wall Street, bringing in returns, building up your estate. While you're free, not in prison, that estate is building into your estate for your purposes. But when you're sentenced into prison or jail, then the money that your estate is returning on these investments is not going into the estate for you. It's going into the payoff for the people for which you're in jail, which could mean millions of dollars a year that's not going back into your estate. And so everybody that is in prison, every prison today is a debtor's prison. I don't care what you think they're calling it. It is a debtor's prison because you're there because you didn't pay your debts.
Can it be set off?
Absolutely. All you got to do is use your what? Take out your pen, get to the right piece of paper, and sign the instrument to compensate them. Now, even if you had a certificate...
And then you have to move it on the public side.
You do. And you got to get it recognized properly, okay? But even if you had a certificate of deposit, do you mean to say they absolutely positively would never allow you to withdraw that money? You can, but what is there for early withdrawal?
Penalty.
A penalty. So that's just more charges. Go ahead and pay the charges and then get the opportunity to withhold the lien on the collateral so that you can collapse the certificate of deposit. So anybody in jail can get out if they know how to do it and if their mind and their heart can stand behind it. Now, if you're charged criminally, you not only have an account, there's something else going on there. You did something in society which makes you persona non gratis. You beat somebody up, you robbed from somebody, you misbehaved some way, shape, and form. And without some kind of reformation in your thinking and in your heart, why are they going to let you out of a criminal prison? Because you're there in addition to not paying your debt, you're there because nobody can trust you as a creditor in society. You're a danger to yourself and you're a danger to everybody else, which is the definition of a terrorist or an enemy of the public. And so you've got to change that presumption that to them you're an enemy of the public, because during times of war, an enemy has no remedy in their commercial system. So you say, I'm going to sign this thing, I'm going to give you the payoff, I want to go home. And they're going to go, all of your procedure was absolutely correct in commerce, but because you're still an enemy and a terrorist, your heart and your mind ain't right, we're not going to give you your remedy because you're a danger to yourself and everyone else. We would be insane to apply the laws of commerce to let you go out unless you've had a change of mind and a change of heart.
So the judge recognizes as the conductor.
As
the conductor, he recognizes that the musician ain't playing the music right.
As Gordon says, this is a perfect system. Doesn't mean some people in it don't make mistakes and stuff, but you have the opportunity for remedy, and you can go. The only thing they promise you when you're born into the world is you come in under the same status as everyone else born into the world. And what you learn and what you do with what you've been given is up to you.
Jack, if they were to execute you...
Why do you keep talking without a mic? And
if they were to execute you,
Smitty?
Y'all, your problems are done. You ain't got nothing to worry about.
Just get a mic so that we're on the tape, you know?
1 second.
I get a question here. How to apply commercial law to appeal a case in court?
Are you talking about a civil or a criminal case?
Family is considered as what?
As what?
Civil.
It's a
family,
civil?
Yeah. family.
Okay, first of all, you're not looking for an appeal, because an appeal, no new facts can be brought in anyways. Okay? So what you're looking to do is do some kind of a private settlement, right? You're going to do something on the private side, meaning who are the parties of the case? And you're going to be dealing directly with the parties of the case to come to some kind of an agreement of settlement. Once you've got a record, and we're going to go over this because these are important elements to your contract. Once you have a record of the terms and conditions of the settlement, then you're going to move that public case to either vacate judgments or orders, dismissal, or if there's still pending performance, or if you're trying to get something undone, then you may be petitioning in some way, shape, or form.
How about if the case is already closed?
If the case is already closed?
You didn't appear in court.
Okay, the case is closed. What are you trying to achieve?
It's on a family law, for example.
But what are you trying to achieve? Like child support?
No, not child support.
Okay.
It's basically it's like, I don't know, it's just like a judgment over the marriage, something like that. It's got nothing to do with the money.
It's got nothing to do with money.
But it's got something to do,
so
for example, like a status of the marriage thing.
Okay, so it was like a declaration by the court?
Something like that.
Like a declaration of, like a divorce?
Yes.
Divorce. Like a decree?
Yes.
Okay, so it was a decree and you want to reverse the decree?
In the way, yes.
Okay, so who were the parties? Who was the petitioner? Who was the respondent?
Husband and wife?
Was it a husband and a wife?
The wife is a petitioner.
Okay, the wife was a petitioner, husband was a respondent.
Okay. What does she want out of this petition? What is she trying to get the court to do?
No, because what happened is when they have like a final judgment from the judge, just because the petitioner didn't show up in the court, and basically the judge say, hey, you know what, our case is closed. But
okay.
Something like that.
All you have to do is go, so the petitioner didn't show up, so the petitioner can go reopen it. You don't have to undo anything. The judge closed it because there was no claim. If the petitioner doesn't show up, there's no claim. So he can't give the petitioner a remedy. So he said, all right, no, there's nothing to do here. Close the case, you can go home, bye-bye.
He may have closed or dismissed it without prejudice because there was no final determination, which means a new case can be refiled stating a claim and having the petitioner show up.
Yeah. So you understand the term without prejudice? Okay. That means that at any point the petitioner can come back in and restart the case.
In other words, it's not res judicata stare decisis because nothing was heard, so they can always come in and state the claim again.
I see.
Okay.
Thank you.
And understand with regard to that, what is interesting is, see, the state is interested in divorces because they grant marriage licenses. But there's a difference between marriage and matrimony. Marriage is the state process of uniting two fictitious corporations together to do business. So that's the husband straw man and the wife straw man for commercial purposes come together and they're treated as a one business unit. And when a divorce goes through, they're just separating the two corporations, both of which are still under the state independently. Now, matrimony is what spiritually goes on between the living woman and the living man when they come together in a spiritual union. And the divorce wants nothing to do with that. Remember, they claim a separation of religion and state. And so the state's interest in marriage is merely joining two corporations for a joint effort. And so when there's people out in society claiming, well, you know, there's benefits through that state union marriage, but that's discriminating because you're using a man straw man and a woman straw man. Why can't we have the same benefits from two women straw man coming together as a corporate union, or two men straw men coming together as a corporate union? And the whole issue of morality or any other thing associated with the spiritual claim of matrimony is an entirely different issue than marriage. You've got to understand the definition of words.
And what's interesting is you could actually still get all those benefits and privileges with the man-man, woman-woman, as you do with a man-woman. It's just understanding the nature of the contract and what those benefits imply and how to obtain those through your contract. So you can still form partnerships, because that's really all you're doing is or merger. You're really merging two corporations to operate as one. And so it can be done. It's just, and in some states, they do allow the men, women merger. But like Jack said, it's completely different than matrimony, than the holy covenant of union together. In fact, me and my wife, there is no marriage, because there's no state licensing documents or anything, because we didn't merge our two corporations. Her corporation is separate, and the corporation that I have is separate. We are in union, a covenant with each other, but that is something outside of government. We didn't need anyone's permission to do that. So why would we need a license? When you go to get a marriage license, what it's for is permitting you to merge two of their corporations. Remember, they're the trustees of that corporation. So you need their permission to merge it with another corporation. That's what a license is, right? It would otherwise be illegal if you didn't have it. So can they tell you who you want to be in partnership for the rest of your life? No, you could choose to be in partnership with anyone for the rest of your life. I think, and I think this is a genius ploy by government, is like right now, gay partners are in a tremendous place of power because they're kept out of the marriage conversation. So really their relationship is based on private contract and covenant. But they're making them want it so bad. They're just making them want it so bad.
If they get what they're asking for, they're going to be under other duties.
Yeah, it's perfect. We'll just tell them they can't have it. We'll just keep telling them they can't have it till they want it so bad, then they'll all get it. And then now we have control over both of them. So now, what's the advantage for the government in that? Oh, well, if you have a tax debt, I can go after you for it. Perfect. Let's get them all into that scenario, so that both parties' property becomes liable under all debts to the government. Right? So make them want it. So we're going to refuse it to them for a couple years so that they really want it really bad, and then they'll all go sign up for it when we make it legal.
To give you an example of that, remember there was all this concept about women's living, women's voting rights, right? Well, there was a reason from the get-go that women didn't have that. What was it? They were totally immune from debtor's prison. You could not put a woman in debtor's prison.
Or could you hold them liable for a debt? And in fact, even if they incurred a debt, it wasn't their debt, it became their husband's debt.
So they wanted rights. Excuse me, watch what you ask for, because as soon as they asked for rights, they had duties and obligations. So they had perfect immunity, and if the husband went to jail for debt, what was the wife's purpose? To grow the family, because she's out, and the kids have a parent. But now, both the husband and wife can go to jail, and now who's raising the kids? The state. Yay! You know, you don't believe this. Look in a scriptural point of view. In the scripture, isn't Jesus called the bridegroom? And who is the church referred to metaphorically as? The bride, okay? Isn't sin considered a debt? Right. Who is it that's paying the debt of sin? Is it you? No, you're part of the church. You're the bride. You're immune. Who's paying your debt? Christ, the bridegroom. He gave you all of this metaphor in Scripture, and most of us in this room probably refer to ourselves as Christians. And we don't understand simple commercial legal principles that the Scripture is teaching you that the bride is not supposed to have voting rights. She is not supposed to have equal rights at everything because she is protected for a legitimate, natural purpose. So just watch what you ask for.
Are we already at time? Okay.
Okay? Another question here. Mike, over here. Somebody else have it first? Go first.
Yeah, so going back a little ways, if you were at an arraignment and the judge is asking you, and how do you plead? And you're talking about pleading guilty to the facts upon condition, upon all these conditions. And Jack, you were talking about how what that question really means is, are you going to pay the debt today
Correct.
Or not?
Yep.
So I take it that if you, from that, I would conclude that if you're talking about pleading guilty to the facts upon condition of, and they're really asking you, are you going to pay today, that you wouldn't be able to really make that pleading unless you had done that private
Not
administrative.
necessarily.
No, you could do it extemporaneous. I can contract.
That you go in,
You could make
what would you
whatever
do before you left the court? What would you do? Go ask for the original charging instrument.
Okay, so but one way or another, you would have to pay, whether you've done it through a process beforehand.
If they said, okay, perfect, and you walk away and you don't get and you haven't done a private payment and you haven't endorsed the original charging instrument, what do you think is going to happen in the next 30 to 60 days?
Come right back at you.
Oh yeah, you're gonna for some reason you're gonna show up back in court and they're gonna have you arrested, and they'll have a good reason for it.
Right.
You breached your contract. You said you were going to pay. They gave you 30 days. You didn't pay. The account is due and owing. It's in collection now. Now they're going to put out a warrant. What is a warrant in the government? What does the warrant do? A warrant is a request for a sum of money due. If somebody in the government is purchasing something, they sign a warrant to go get it, which means their department is going to pay. Okay, so the cop shows up at your front door now because it's 31 days. You said you were going to pay at the arraignment, and you didn't. And the cop is knocking on your door, and he says, "Are you ready? We've got a warrant for your arrest." Why do you think he's there? The warrant says you promised to pay, and we've got a warrant that is going to ask you to do what you said you were going to do. So if the cop says, "We got a warrant for your arrest," how would you respond to that right there? What would you say to him?
I'd ask for the original and endorse it.
How may I help you, sir? You say you have a warrant. Do you have the original with you for my inspection so that we can handle this matter right now? If you're the creditor, what are you going to do if he's got the original with a blue ink signature and a seal of the clerk on it?
Flip it over and endorse it.
Turn it over on the back and you're going to endorse it. Hand it back to the cop and say, "Well, thank you very much, sir. It was nice of you to come on out so I didn't have to come in." You can take that back to the court. Tell them hello for me. "Thank you very much. It's been nice doing business with you. You have a nice evening." And the door closes.
The chances are that's not going to happen.
Well, there may be a little bit more to the test.
The police officer is probably going to look really confused because they don't understand, as much as you may want to believe, they don't necessarily understand the intricacies of contract law, even though they are trained in it, but they don't know they're being trained in it.
And I guarantee you they didn't bring the original because that's a valuable piece of paper.
Yeah,
and
it's sitting at the court.
Just more every guy, debtors doing their job. They're bringing pieces of paper.
And 9 times out of 10, they're not even signed. They don't even have a copy of the signed warrant. They just have a warrant.
Or it's in my computer here. Would you like to walk out to my car and look at it? And as soon as you clear the threshold, you've got the snaps on you. Yes?
Yeah, Jack, if I were inclined to make a conditional plea of guilty, would it make any sense at all to maybe have, and I'm talking something really simple, a traffic thing or something, if I were to have my conditions written on paper so as not, in respect to the court, so I don't put the judge on the spot and all the parents yelling, yeah, I want some of that,
Right.
Submit it to the bailiff.
You could even say, Your Honor, may I approach the bench? Right?
Yes. Or I have
because you're protecting the public.
Here.
You're protecting the public. Your Honor, may I approach the bench for the purposes of protecting the public from proprietary or private information?
I have a security agreement here. I would like to give notice to the court. May I approach the bench or have a sidebar?
Now, we've had people who know nothing about commerce who have come to us for help. This is the advice I've given them, is the pleading guilty to the facts. And it's had remarkable success for people, okay? Especially when they do it right and they appear competent to the judge. Okay, we had my brother's ex-girlfriend. She was a sales rep for a pharmaceutical company. Okay, so she had a really nice company car and everything. And she got popped for like doing 30 or 40 miles per hour over the speed limit, which is like serious like endangerment and all these other things, right? Basically, the points that would have gone against her license, which is through the DMV, really has nothing to do with the court, would have had her license suspended and she wouldn't be able to do her job. She would lose her job. I mean, it was a big deal, right? But what was she going to do? Go argue that she wasn't driving that fast? So we explained to her, go into the court, tell the judge, I'm here to plead guilty to the facts, and I wish to effect payment immediately. And we told her, hold a pen in one hand, hold your checkbook in the other hand.
Conditions?
No, we didn't even give her conditions. We didn't want to try to teach her contract language or anything like that. We just said, plead guilty to the facts. Because there's no dishonor, that should have been like an $800 or $1,200 ticket. It was $145, and nothing ever went on her driving record. The judge goes like this, I know what you're trying to do. He goes, but I can't accept your check directly. He goes, when you leave the courtroom, write the check and give it to my clerk, and write it for $145. Now, if she'd have left the court, I guarantee you she would have got a bill for $800, $1,200 if she wouldn't have cut that check right then and there.
Let's also go back and qualify a couple things because people are loose on their language. You said, I am going to enter a plea of guilty to the facts. The only one that can technically enter the plea is the defendant. And remember, you're not the defendant. Okay, so the language we're using as the accommodation party, we are authorizing the defendant to enter a plea of guilty to the facts in order to resolve the public matter. Okay? Now there's two other pleas that you ought to be aware of, and go to Black's and look them up. There's such a thing called plea and discharge. Remember how I said in my hypothetical case, I'm going to do the paperwork that says I got a certified copy of the charges, so I've received that, or at least the defendant did, and I, as the accommodation party, which is the creditor, not the defendant, because the defendant can't pay. He hasn't got anything to pay with. Although what Brandon just said is she was coming in with her checkbook. Is the checkbook public or private? It's public. So she's using liability funds to set this off. But she's being in honor. She's not arguing. She's doing everything in the court to reduce the court cost. She's being honorable as a creditor on the public liability side, so she gets extra brownie points for that. But when we're coming in as the legal title holder, as the creditor, you're authorizing the defendant to do that. If you enter a plea and discharge, if you look that up, it says that the plea is to the facts that you've already set off the account, and it no longer exists. Well, if we've already tendered something to the clerk to set this off by being responsible for the charges in the case that we are standing under, when we go into open court in the first hearing, and the judge says, how do you enter a plea, guilty or not guilty? Well, Your Honor, I've been authorized today to enter a plea and discharge. the record of this matter having already been set before the court, you're definitely going to get the judge's attention, because it's saying it's already over. There is also a plea called an Alford plea, A-L-F-O-R-D. Look that sucker up. And in a criminal case, an Alford plea is like, in a civil case, a plea of no contest. In other words, I'm not going to plead guilty to the facts, I'm not going to plead not guilty to the facts, but I'm going to allow the court to presume that we're entering a plea of guilty to the facts to help resolve this matter. So an Alford plea would be used so that you don't want to enter any specific plea in fact to a criminal case, because there may be a civil case as a collateral issue, and you don't want the voluntary entry of a guilty plea to affect the outcome in another case that might be a collateral issue to this. And so theoretically the Alford plea might also be something we could do, but I don't think we even have to go there. When we say we're willing to plead guilty to the facts, you don't want to just say that. Because remember, they're making you an offer. And in their system, in their offer, isn't everything in the public? And the public's going to presume that we're going to apply our public policy for criminal. There's a mandatory jail time on this felony. Is that what you want to consent and agree to with your plea of guilty to the facts? No. So you have to make a full counteroffer. You're willing to plead guilty to the facts to do what? To establish the account liability. Is this account $1 million? Is this account $10 million? Is this account $1.25? Because pleading to the facts on what the straw man's charged with determines the level of commercial liability. And you don't want to dispute that. If you come in as the accommodation party, do you want to say, well, I don't think that you ought to charge this guy with that claim? Remember, only the parties can argue the facts. And who's the party in this criminal case? Is it the accommodation party or is it the defendant? The defendant. So if you come in as the accommodation party, can you start arguing about what the defendant's going to get charged with and what he isn't? No, because as soon as you start arguing any of the facts in that case, you have now become the defendant, because he's the only one withstanding to argue the facts. If you're coming in as the accommodation party, you got to let the facts alone. You got to let the offenses or the defenses alone. You can't argue any of that stuff. You're just there as Daddy Warbucks to pay off the debt of the defendant, and you can't get involved in any of the matters in this case. So you're not going to end up doing that. You're going to come out and plead guilty to the facts, and the additional contract is what? The additional contract is no jail time, no probation time, no public liability and prejudice to the defendant, because you've already settled it. Okay? I guess we're on break. We're going to lunch.
Is it 2? Is it 2 o'clock? What time are we coming back?
These Mastering Commerce workshop sessions, here and after sessions, are the private exchange of ideas and concepts between the providers and recipients. The content is not meant as legal advice. The use or attempted use of any idea or procedure discussed in these sessions is applied to recipients' own personal transactions, cases, or controversies, or applied to other cases may or may not result in a favorable outcome or the same outcome as discussed in these sessions. Each transaction, case, or controversy may be different as a result of unique actions or unique statements made by the parties therein, and each different act or statement in any transaction affects or may affect whether any procedure or idea discussed in these sessions is relevant to the recipient's transactions or that the outcome thereof will be depicted as in these sessions. The discussion of ideas or procedures in these sessions is not exhaustive of the subjects being discussed. Many ideas and concepts that can affect the outcome of any legal or commercial procedure are not discussed in these sessions. In fact, that the recipients may not be aware of these issues may have an adverse effect on the outcome of the recipient's procedures. It is the responsibility of the recipients to understand their own transactions and to apply the appropriate and complete concepts necessary for a procedural and substantive remedy thereto. These sessions may be redistributed privately by any recipient to another recipient requesting them, conditioned upon the fact that this notice is provided therewith. If you have any questions, you can contact Mastering Commerce by email at info@masteringcommerce.org.
So
not lot enough.
Without contract, you don't have society. You know what I mean? You don't have a functioning society. And anytime any leader has tried to take away contracting, that society lasts very short time. It's crumbles within a very short amount of time. And everyone knows this. People who we would, I guess, call leaders, they know this. And in reality, you take away the capacity to contract and you take away all their power as well. Because anyone and everyone's power is derived from, are we recording? Okay. Is derived from their power to contract. Plain and simple. How did the Rothschilds get the power that they have? Contract. Plain and simple. You know, so do you think they want the ability and capacity to contract to go away? No. Because they know as soon as it does, then it becomes power struggle. It becomes a fight. And whoever's got more guns wins. You know, then basically everything boils down to might. You know, and they don't want it to boil down to might, because when it comes down to it, who's got all the might? The people. There's 7 billion people. That's a lot of people. And if it comes down to it, we've got all the power.
All power rests in the hands of the people. The only thing is that powers that be don't want the people to get together and get smart enough to understand, number one, that they do have the power, but just power in and of itself, improperly used, is going to be chaos. So you have to understand how to use it in a manner which is acceptable under international private law dealing with contract.
I'm going to quote Stan Lee. With great power comes great responsibility. And he did that through Spider-Man. Right? Spider-Man had great power, and the realization was with great power comes great responsibility. And that's what we're teaching. That you have this great power, but with that power comes a great deal of responsibility. And until you're ready to step into the responsibility part of it, thank God we have the gatekeepers who will make sure that society runs and functions. Because that's, in a republic, which is what we supposedly have, that's the only thing keeping us from absolute chaos is the judges. You know, the judges is what it comes down to. And even in the days of Moses when they were without a king, what did it come down to? The judges.
If you go back to the Old Testament in the book of Judges, and you start reading the introduction, it'll tell you at that time in Israel, all they had was the people, and everyone was doing his own thing. And so why did they instill the power and office of the judges? The judges were the trustees over the people who were just doing their own thing. And if you think people doing their own thing always get it right, they never do, especially if they're uneducated. So why did the land of Israel have the power of the judges before they got the office of the king? Because the judges were the trustees to keep the people in the land from sinning so much that God would bring a judgment against the land. What do you got in America today? Don't you have people basically doing their own thing? But we have superimposed in America a judicial system. Let me ask you a question. Is this judicial system anything like the original office of the judicial system under the Constitution? No.
Well,
These judges are under what?
There's a legislative court and a judicial court that are happening simultaneously. Now, most of the time you're in court, you're under a legislative court, which there are no judicial determinations in a legislative court. Only administrative determinations are made in a legislative court. Why is there a legislative court? Because a majority, 99.9% of what's happening is under statute, which is legislation.
And the statutes are the rules of the democracy,
the corporation
which
itself.
is an overrun government, overrun by the military, to which the commander-in-chief president is the head of the military. So you do not have an independent judicial. You've got a court-martial judicial operating under the democracy. You do not have an independent legislative. You have a legislative advisement to the democracy run as a military government. And so everything is administrative process. They're basically trustees to do what? They keep the people who are doing their own thing in line. So we're right back to where we were in the Old Testament again. Nothing changes. History just goes around and around.
But when people step up to be responsible and to operate under the common law and under private rights and remedies, the judicial, it's as if it comes to life. And I don't know if all judges understand this, but I think a lot of them do, that they play a dual role. That they play the legislative, where they make administrative determinations, but when called upon, they can make administrative or judicial determinations as well. I think we see most of the judicial stuff happen in what we call in chambers. So it seems to me that if there were two sides to the court, what's happening in the public, what's happening in the courtroom when the judge is in his robe is administrative determinations, legislative court. What happens when the judge takes off his robe or you meet in chambers is judicial determinations. So you've got access. But in order to use that side of the law, so to speak, or that side of the court, you have to demonstrate that you operate responsibly in the republic without the franchise, without the benefits, without the privileges.
Aren't all those benefits and privileges, that's just another contract we've gotten ourselves into, right? Mm-hmm. And they know you're in this contract when you go in there.
Well, they don't know that. They presume it.
Well, it's already under presumption, right?
Yeah. Like, for instance, if I were in court and they were to bring up, let's say they have some kind of a master record of the straw man named Brandon Adams, what they would see is that has no property, doesn't take any sort of benefits, doesn't pay into any kind of a benefit system, right, is basically by record doing nothing. It doesn't exist. It doesn't have a driver's license. It doesn't operate in their world of commerce.
But the regular guy, he's like me.
And that's actually what we're going to get into right now, are the
driver's
hats.
License and
and there's nothing wrong with that, because there's a way to be effective in commerce while wearing all those hats. You could still operate a straw man. It's about understanding who you are so that you are truly operating it as if it is something separate from yourself. The problem is when you believe that you're a name. And I don't care how the name's spelled. I don't care if it's uppercase, lowercase, hieroglyphics. It doesn't matter. The name is always a fiction. Whether that fiction is a franchise of the United States or whether that fiction is a privately generated entity is to be determined based on what? Your actions, your conduct, how it's expressed in contract. Right? Like when I write a contract, it's very clear what entity you're contracting with, that this entity is not a franchise of the United States, that by even being in contract with the entity, you're waiving any and all franchise benefits, privileges. Okay? So there is no limited liability in this contract. Okay? If you're entering into this contract, you're doing so without that straw man, so to speak. I don't care what name you want to use in the contract, but we're clear that in this contract, that franchise is not allowed. Meaning, if there's any dispute in the contract, I've spelled out how the dispute is to be handled. You see, because one of the benefits and privileges of operating that franchise is that you've got the disposal of the court system to handle any contract disputes, right? But in the private contract, I've spelled out that that is not an option. That the only option for dispute resolution is a private dispute resolution process through a private court or third party, whatever it is. But by entering into the contract, you've agreed to that. So just like your landscaping contract, if it was expressed and spelled out that we're not operating under franchise, that we're expressly operating under whatever you want to call it, under common law, private international law, right? You guys have seen the governing law clause in contracts, right? This contract shall be construed and enforced under the laws of the state of California or under the laws of the United States, right?
Jurisdiction.
It's setting the franchise. It's saying that this contract is protected under this franchise. And what do they do in the initial pleadings of a court case? Right. They say what the name is, that this person is a resident, right, of the state of California.
So the name is a franchise.
Okay, so they're spelling out that showing that the court has jurisdiction. Because if you weren't a resident or a citizen or anything else, the court would have no jurisdiction. Because that status of resident of state of California is something that falls under the Superior Court of California's jurisdiction. If you weren't a resident, or if the property wasn't in the state of California would have no jurisdiction, right?
Yeah, they're talking about a straw man.
Right, but that's what you're there for.
They're talking about the straw man.
That's the only thing they charge. If you didn't use the straw man and didn't have a driver's license and all those other things, how could they make you the same as the straw man? Why would you care what they were charging the straw man with? The fact is, you got bank accounts, you got property, and you got all these things in the name of the straw man, so you're using it. So you show up because you're freaked out. You don't want them to charge the straw man because there's all this stuff that you've got under the straw man that's in jeopardy, isn't it?
But you could show up as the accommodation party.
Right.
If you show up as the accommodation party, are you under those jurisdictions or any of those presumptions that are in the leading paragraphs of their court case? Not unless you want to be. Okay, so you're totally alien and foreign to anything they've just said. So the issue is, what's your point? We're here to set off the case.
Okay, so let's look at the different hats, so to speak, that we wear in relationship to this straw man. Because this straw man is a corporation, or trust, put it simply. It's a trust formed under the franchise of the United States.
Yeah, trust is too reality. A lot of patriots are trying to file 1041 tax returns on the straw man, but that's too much reality for them. They don't want to see that.
They've already got a special class. They realize it's a trust, but they have a special class of trust that they call individual. Mm-hmm. And an individual is a special kind of trust that files a 1040 form. Okay? So, in tax code, this trust is known as an individual. Okay, individual taxpayer. Now, explain to me, Jack, the accommodation party.
Well, remember in Scripture in chapter 4 of Genesis, you have the first tax protester, and that happened to be Cain. Because the sin in the Garden of Eden was reckoned as a debt. And so Adam and Eve were told at the tail end of chapter 3 that they had a debt. And they realized when you have a debt, you got to pay something on the debt. And if you can't pay it all at once, you got to pay it every moon, which is every 30 days every month. And at first, remember, Adam and Eve said they were naked and they covered themselves with leaves. But at the tail end of chapter 3, the Lord said, no, that's not the money of account. And God slew animals and gave Adam and Eve the pelts, skins of the animals as a covering. The blood of the animal was the money. And the pelt, now, the dead animal, is the receipt for the payment of the tax. And remember, if you've paid a debt for the month on an installment, you say you've covered the debt. So the nakedness was, in essence, their understanding that they no longer stood with God, they were separate, and they needed a covering every month, a receipt for a payment of an installment. Now, since the blood was the declared money, you had two offspring of Adam and Eve, one called Abel and one called Cain. And in chapter 4 we have the first tax protester, because the Lord went looking for Cain and said to Cain, "What the heck are you doing? You are not paying your taxes, i.e. your debt installment, properly on a monthly basis." Now Abel raised animals, and he made a sacrifice of the animals to do his monthly payment in blood to God. And it was acceptable. But Cain was a farmer, and he decided that when he went in to pay his mortgage to the bank, he was going to take some fruit and vegetables in. And the Lord was coming to him as the banker saying, "That's not legal tender. I cannot accept your payment." And Cain is arguing with him, and the Lord said, "Unless you give me blood, you haven't made your payment." So Cain goes out, slew his brother, and gave the Lord his brother's blood, which is now compounding a lot of problems, because number one, you can't take property from your neighbor to pay your debts. It's called theft. Secondly, thou shalt not kill. You don't have the right to take the life of your brother. But the point is, the Lord said something about, "Are you not your brother's keeper?" And if you've seen the movie Cloud Atlas, you will know that they're saying that every event that happens, civilly and criminally, affects every one of us, because it ripples on in nature and causes all kinds of problems. We are our brother's keeper, which means that we have to accommodate our brother. If you see he has a debt and he cannot pay it and you are his brother, if he asks you and you can help him, you must do so. Now, our straw man are not technically our brothers, they're fictions. But nevertheless, you helped create them through that grantorship role. And whatever you've created, you're responsible for. And because you have created him and he's gotten himself in trouble, you have to deal with the trouble that your creation has caused. And if you don't deal with that, then you're held accountable. How many people saw the movie Prometheus? Do you remember in that story, which is the prelude to, or prequel to the movie Aliens? And Aliens was out like at the end of the 1980s or something like that. And this movie is a prequel to it. It dealt with a corporation on Earth sending a spaceship way out to investigate. The first one, Alien, was a derelict spaceship. And the crew was supposed to meet with this, transfer the cargo on board the derelict spaceship and bring it back to planet Earth, because the corporation wanted to retrieve it. It turned out to be that alien monster. The reason that the corporation wanted it is because it was so dangerous, they wanted to turn it into a military weapon. And you saw what it did. It just about wiped out everybody on the voyage except the captain. Prometheus is a prequel in which there is a story of the same corporation sending out a mission about 30 to 40 years prior to the mission for Alien. And they went to a far distant star system, probably under Orion, because they believed that the gods, they called them the architects, that had created life on planet Earth. They came down to Earth and seeded life, then abandoned their creation. They believed that the architects, once they got up to Prometheus to investigate this, were coming back to planet Earth with the goal of exterminating all man life on Earth. And the question that they posed in the movie Prometheus was, why would the gods that created life on Earth want to come back and kill us? Just go to the scripture. Did not God create man and put man on earth? And later on, he looked down on earth and he said, look what kind of a problem man is doing down there. We've got to wipe them all out. If you create something and it gets outside your control, you're responsible for it. Now, what God ended up doing is he came down and wiped out all of mankind except for 8 people who were on the ark. 8 stands for new beginnings. They never answered the question in the movie Prometheus why the architects would want to come down and plan on wiping out life on earth. But we already know the answer to that, and in the movie it gives them an excellent opportunity to have a sequel to the prequel. But the point that Hollywood is making is, as a group of 7 billion inhabitants on planet Earth, aren't the majority of the 7 billion so incompetent that they can't handle their own affairs, let alone get along with each other? Isn't there right now a public monument in the state of Georgia that's been there for a period of time, which has literally said that the destiny of mankind should be a society of a balance of around 500 million people and no more than that? We can't even fix our own problems, let alone be our brother's keeper. But we are told by accommodation that we must look out for our brothers. But if we can't even look out for ourselves first, there's a fat chance that any of us are going to be looking out for our brothers. But they've given you a perfect metaphor here. Even as mankind who fell into sin has no capacity to set off that debt, because he has no currency that can be used to pay the account. You have to have a lamb that has blood and is an innocent lamb, having never sinned, to have the lawful money of account to pay off the debt. And what man has not sinned, other than if you believe the scripture, there was one that came to life without sin, and his blood was shed as the de jure money, not a de facto money. Because the sacrifice of the animals all the way through the Old Testament was a de facto money. It didn't pay the debt, it was symbolic of paying the debt. Had it not been for Jesus, the accommodation party for the rest of us, there would be no plan of salvation in the sense of the biblical telling you about debt and redemption. Your straw man was created in sin. I mean, he was not given access to anything except public debt. You can't pay off public debt with public debt. That's called a novation. It is not called a payment. So unless the living man who has the capacity to get the money that is equivalent to asset, having both legal and equitable title to its units, comes in as an accommodation party for his own straw man, there is no ability to get your straw man out of trouble because there is no remedy in the public. You've got to go over to the private side in order to get your asset funds to have that remedy. So everything that we will be teaching you in terms of a remedy, in court, in your private administrative process, personally knowing, as I came up here after lunch here, one of the gentlemen said to me, so let me get this straight. You're saying I can just write another promissory note and get my remedy? And the answer is absolutely yes, if you're writing that promissory note as an accommodation party creditor, not as the straw man. So what Brandon is taking you into right now is the absolute foundation for all remedy. You've got to get back to the equivalent of the lawful money, which only comes from the private side. And your only remedy is to deal with these accounts by what is called accommodation. And in the Uniform Commercial Code, you'll see it under 3-419. And that gives you the right as accommodation. And you got to understand that if you're going to accommodate another party, you as the accommodation party are getting no direct benefits. What that means is you can't own what it is that you redeem for your straw man. Only he can own it, but you cannot, because ownership is debt. And you're not doing it to claim anything other than to help your brother.
So what is an accommodating party? Does he represent? What does represent mean? What's that? Represent. Represent. To present again. So is an accommodating party representing or even have the authority to represent the debtor? No.
Is it the trustee?
In commerce, if you present someone, who are you presenting them to and for what purpose? You're the subject or the servant. You're being introduced as the servant or subject to the sovereign. You don't want to be presented. You are who you are. And as if you believe that you have the capacity of a sovereign, you're not presented to another sovereign. You might be introduced to another sovereign, but to be presented or represented, represent means you're being brought back from having not been the subject, and you're now going to comply and be the subject. Remember, an attorney represents a client. Or the court says, would you like to represent yourself? No, not really. I am who I am. I don't want to present any fiction back to you and become the fiction. So the answer to the question is the accommodation party is not representing anyone.
So that's an important distinction, so that you don't make the mistake of having that in your language or in your thoughts. You are not representing, or the accommodating party is not representing anyone. So if the accommodating party is not representing the straw man, what is the accommodating party?
The agent for?
The agent for what? What's that? Provider. Pays. Okay.
Is he taking the liabilities on behalf of?
Is he taking the liabilities on behalf of? Okay. Becoming a surety for the liabilities? So what is the relationship? What makes sense? If we're going to be an accommodating party and we're going to be discharging or setting off debt of the straw man,
Doing something on behalf of the straw man.
you're doing something.
You're doing something on behalf of the straw man.
Okay, so you're acting.
You're acting.
Okay.
So the good example for is like, let's say I'm a mother paying on behalf of my daughter. I'm taking the full responsibility of the debt. You know, I'm being liable or becoming a surety of my daughter who's going to have the ownership of the car, for example, but she's not going to be liable. That would be the example. So I'm being the accommodation party for.
As the accommodating party, do you have the liabilities of the party you're accommodating?
No, you're assuming the liability.
Assuming the liability.
Are you assuming the liabilities? Or do the liabilities remain with the party you're accommodating? It remains with the party you're accommodating.
So, wouldn't you be like a trustee in some sense?
Tell me more. What's the trust?
The trust would be a private. There's two trusts, right?
Well, there's a lot of trusts.
I mean,
there's a lot of trusts.
In this particular capacity, there's like two trusts, right?
What would be the corpus of that trust?
Of the private trust?
What property are you putting into that trust that you're just describing?
That'd be the body.
What body?
This body. No?
No, there's another trust that holds the body. What
That's
property are you putting into this trust
that'd be
that you're
the
creating
estate.
by accommodation?
It'd be the estate.
What estate?
The private asset estate.
No, it's already in another trust.
Okay, then I'm talking.
It was in the Social Security trust.
That's in the Social Security.
What are you transferring into this trust? See, you said trust, and Brandon picked up on that, and he's got this aha moment, and he's trying to get you to think of how many elements are in the trust.
Well, there'd be substance. What's the substance, right?
Well, there's a grantor, there's a trustee, there's a beneficiary. Describe that, but then the trust doesn't work unless you put some property in there.
You don't have a trust.
What property is going into this trust that we're dealing with by accommodation?
The account or the debtor?
The debtor account. If he owes a tax, this accommodation to pay that tax, the property going into the trust is the debt account for that tax for that taxpayer. So it's a straw man's taxpayer debtor account. That's the property. Okay? Who was the grantor? Who is the trustee? And who is the beneficiary?
The beneficiary is the straw man or the creditor, and the trustee, the grantor, would be the accommodating party.
Just guessing.
Okay.
Close?
Close. Anything with a name or a unique identifier, by definition, is a trust. So even an account, like for instance, federal court case number 3:2012-6635. That's an account, and there's a trust. If it's got a unique identifier, there's a trust to it. Okay, so the straw man, does he have a unique identifier? What is the unique identifier? The name with the Social Security number. So that is a trust. The debt accounts. What debt account are we dealing with?
Is this a court issue we're talking about?
What's that?
Is this a court issue?
We could do a court issue. The case number. Okay, so there's the court case becomes a debt account. Okay? So as the accommodating party, where do you fit? What is your relationship to the debt account and the straw man? Well, here, let's first, what's the straw man's relationship to the debt account?
Would they be the grantor?
Could he be a grantor? Who's got duties and obligations in a trust? The trustee. So, what's the straw man in the debt account? Initially, he's a trustee. What happens when a trustee doesn't perform? protector steps in, right? Who's the general public protector? The judge. Okay, so, but what if someone steps into this abandoned role? Now, can the straw man, who has no lawful money, who has no assets or property, can he do anything with the debt account?
No.
He can't settle it, right? He can't set it off. He could take a benefit and privilege and go to jail. But who, in that scenario, who's settling the account? Who's taking responsibility to settle the account? The judge.
Protector.
The judge is taking the responsibility to settle the account. Okay, so if we don't want the judge stepping in and settling the account, what does the accommodating party need to do? Settle the account. Step in and settle the account. Right? So what role would you be stepping into? Trustee. Okay? So the accommodating party steps into the role of trustee for the debt account.
So the accommodation party is doing in private what the judge of necessity is doing in public if the old trustee, the straw man, stands back and does nothing. And so you can settle it privately, or you can do nothing and settle it publicly. But you can't settle it through the old trustee, the straw man. You have to have a protector, an accommodating party.
Okay, so now we also use the term often of paramount security interest holder. What does that term mean? Paramount security interest holder. What is a security interest? It's a lien. What do you mean by that? What is a lien? A claim? A claim to? A right to? An interest in? Right? So, what is paramount? The highest, superior, priority over all others. Now let's think about the trust that you're currently engaged with now. You talked about a body being in the trust, right? The physical body. Who's the paramount security interest holder? Are you sure?
Well,
when was their what was their date and time of their claim?
when the birth certificate was registered.
When the birth certificate was registered. Right? What, are you dancing for some reason?
Yeah.
What is my microphone's on?
No, I was saying.
Oh, you had an answer? You had an aha? Oh, the I. Okay, so the I, the true you, which isn't the body. You're not the body, you have a body. Right? Who are you?
Life force.
Who are you? Are you sure? Because I would say you have a soul, but you're not the soul. The soul is an aspect of you, something you have, just like a body, just like a mind. You have a mind. Are you your mind?
Yeah, no. Body, soul, and spirit. The body is the physical. The soul is the animating life force to the body. Because when you are deemed to be a dead body, it's said that the soul has departed from the body. The life is in the soul. So the soul is the attribute that gives life to the body, but it's still not you. You are the spirit.
Is there an answer to this question? Who are you? Who are you? Who are you?
I've never seen my spirit. I can't describe it. All I know is I am.
So, and that's an interesting analogy that they even use in Scripture of the I am. and the ineffable. Because there's an element of you that can watch your thoughts, that can experience emotions, that can experience the physical body. So it's none of those things. If you're observing thoughts, which you can do, can you see your thoughts? Can you hear your thoughts? Can you watch your thoughts? Yeah. There's an element of you that can actually observe the thinking element, which is the mind. So it's not you. There's an element of you that can experience emotion. The emotions aren't you. There's an aspect of you that experiences the body. That's not you. Now, this is an esoterical conversation, and this goes deep in all religions and philosophies. The who am I? Who are you? And the minute you label it, that ain't you. Because anything you label, soul, body, mind, emotions, anything that you label is now content, not the context. Does anybody even know what I mean by the distinction between content and context? Okay, so what is the context of this training or of this workshop? That's content. What is the context? What's that? Energy? That's content.
It's just before, that moment before you think it is, that's content.
That's content.
The room? Tables?
That's content. Tables are content.
Yes, that is.
Content. Learning is content. Becky? No thing. But you just labeled it, so you just made it content. See the problem we have here? As soon as you start to label it, that's not what it is. Because you're more in the sense of context of being. Now that I've labeled it, it's not that either. But that's essentially what we're getting at is you, in your truest form, are the context of being, which includes a soul, it includes a body, it includes an emotional experience, it includes everything that you can label and observe. Yet, that which observes and makes distinctions is the context. And then as soon as I label it, it becomes content. So, any name is a fiction. So when I said, who had paramount security interest in the body? And you said, I do. And I said, well, who are you? I'm not doubting that you have the paramount security interest in the body. Because let's face it, you were there first. Right? You were there first. So if you were the first one there, in the body, of the body, connected to the body, having the body, so you had first claim to the body. Okay? So, and from the body, we have labor, right? We are behind moving the body. We're behind creating with the body. So we're behind generating with the body, correct? And we generate with the mind. So the I, that thing that can't be labeled, has an interest in everything generated and created through the mind, body, spirit. Correct? So first claim to all of it. So when the straw man gets introduced and property starts being generated through who has the interest in the labor? I do. And so I have first claim to all the property that gets placed into this trust, don't I? And remember, we were talking about security interests earlier. Does my interest ever go away? No, it's always there, but I can assign it, can't I? And so what happens is interests of our labor, interests of the body, all get placed into this trust. Right? Or in trusts like it. Because if we're talking about the straw man as the Social Security Trust, there was a trust that existed before that got into a contract with the United States to create this. And that may be the trust that the body is in. Because the first trust was created when your parents said, oh, I'm going to call it Brandon Alexander Adams. They gave it a unique identifier, didn't they? And if you look at that life, you could look at, in that trust you had God, that force that creates, as the grantor, mom and dad as the trustees, right? And the world as the beneficiary. That was the first trust. We can call that the origin trust. So it has this unique identifier. And a lot of times we make a distinction of this trust. We call it the living man. But it's a fiction because you gave it a name. But your implication of calling it a living man, and I've heard people say flesh and blood, living man, right? Is that it was the origin trust in which the body was placed. And you've taken on the role of trustee for. So are you the name? No, not in any form. Mom and dad gave it a name. And you decided to operate in commerce through that name. And the first contract you got into created this franchise. So the body was originally in that trust, the origin trust. Does it ever give up its interest in the body? No. So now we've already got, before we've even made it into public commerce, we've already got two trusts. And then this trust was created. And an interest in the body was conveyed. How do I know that?
Because of the certificate.
What's the evidence of that? Birth certificate? What else? Well, that was on the application for the birth certificate, right? So you were placing the body into a trust, right? And so you had to identify the property, right? Just like we need a VIN number, right? We need a VIN number to put the car into a trust. What do we need to put the body into a trust? A unique identifier, right? Unique identifier, right? So footprints are a unique identifier. And then it gave it a name. This is before there was a number. So that's another trust. And then that trust contracted to create what the trust that we deal with the most in public, which is that trust with a number. It's got the name, all capital letters, and the number. Unique identifier. So there's already been a conveyance of interest in the body at least 3 or 4 levels before we get here. And then, if we're going back to this being a court case, well, let's say it's a criminal court case. If you're found guilty and sentenced to 7 years in the warehouse, has there been another conveyance of interest in the body? Right? Into this trust. And then is this trust revocable or irrevocable? Revocable. It's revocable.
What if you get life?
Even if you get life, it's a revocable contract. It's a revocable trust. Because this trust is a revocable trust, isn't it? And so is the birth certificate trust. That's a revocable trust. Now the origin trust is revocable. It's just, do you want, may be difficult For some, maybe for others it's easier. But it's revocable. It can terminate and be terminated intentionally. That's revocability.
Would you be willing to take a moment and go back to the first trust you're aware of and just kind of along the timeline of a man's life, or even predating his existence due to other contracts that are in place and that he kind of steps into through his parents or whatever?
Right. Well, nobody can contract for you other than you unless you're incompetent by way of age or disability. So anything that existed before you were born into the world actually doesn't influence you in terms of the worldly things. The only contract that deals with you before you were born into the world that you got to deal with is part of the origin trust with God, because you were born into the world with what is called inherited sin. And that just means inherited debt. It didn't mean that you came into the world and you didn't even commit a murder or theft or anything. It meant that it's implied upon you. Because understand this, under the law of debt, whatever collateral belongs to the debtor until the debt is discharged or paid is included within the estate to pay that debt off from the beginning. And so Scripture defines the spiritual thing that brought you into the world with a disability is that our parents, Adam and Eve, fell into debt. Did they ever pay their debt? Ever. Not of themselves. They needed an accommodation party, right? Okay? So, because the offspring of the man is his property, all future generations are under his liability to pay that debt. So, original sin or inherited sin is nothing more than being described as, we don't care if they're unborn and born into the future until somebody pays off Adam and Eve's debt. They're still collateral that are under debt, and hence they're under original sin.
And let's look at the body itself. You're borrowing the elements that make up the body. It's borrowed property. So there's an implied debt because you didn't bring the materials of your body into the world with you. You came into the world, inhabited the body, and are temporarily, you're constantly borrowing from the planet itself to maintain the body, aren't you? When you consume food and it breaks down to make up the rest of your body, you're borrowing it.
Now when you look in terms of things that are going on in this world is the world of the fiction and the government and the bankers. The world is reality. So we can talk about the world and this world. They had no contracts on anybody in the world. It only comes on you as you come into this world. See, the whole reason why the abortion program is what it is because until you are born and registered, the government can claim no property rights on you. So that whole history of abortion, the question that was asked in the abortion bills in the courts were, could the woman have the right to determine what was going to happen to the issue of her body as far as this world, the corporate state, was concerned? And what the judges went back and said, we don't have any contracts on the fetus. We don't have any contracts on the fetus until we get the hoof print after it's born alive.
Hoof print.
So it makes never mind to us what the hell goes on. It's outside our jurisdiction. So in essence, they did a confession and avoidance. We're not going to say it's legal. We're not going to say it's lawful. Well, we're not going to say it's right or wrong or lawful. We will say, as far as legalities are concerned, since nobody's got a claim on it, we could care less what the hell happens to it. You see what happens? And it doesn't say it's right or wrong, morally right, morally wrong, or anything else. See, in Scripture, in most religions, the Lord said, I knew you from before you were even conceived. So in that original
that's where the original
world,
contract is made. Before you were conceived, there was the contract.
You got it. But not in this world.
Origin.
So if you're going to talk now about how did the corporate state get involved in any of these contracts, it didn't get involved into the contract till a baby came into the world. It wasn't yet registered, so they couldn't deal with the baby. But was the mom registered? You bet. She was one of the slaves on the plantation because she was registered. And any time the plantation had a birth, it was property, and who'd the property belong to? Belonged to the plantation. So you had a birth through a registered mom, and now they go to mom and say, you have anything announced to the plantation? Oh yeah, by the way, there was a property delivered to the plantation. Well, let's go ahead and register it then. You see what's happening? So they didn't bring anything on you until your mom registered you in this world. And as soon as that happened, they're just sitting back for 18 years to see what you're going to do about it, because they got to get your consent to ratify what your agent, your mom, did with you. Because everybody is born into freedom and opportunity, unless, of course, you want to give it away pursuant to Exodus 21:5. If you love being a slave, you can go in front of the officials and say, I want to be a slave, and they will allow you to be enslaved. So at age 18, you got a 30-day period to be enslaved. Now, when mom registers you, like Brandon said, she registers you under a name. That name now becomes the property description. And who is the holder of the use for that name? Who's got the rights to it?
Who'd you register it with?
Yeah, whoever it's registered with.
Think about this. You guys ever heard of the term in persona conjuncta? In persona conjuncta. There's a term used in trusts whereby, or it's used beyond trust, but specifically in trusts, the trustee has all the rights and powers of the trust itself. So, in mom applying, right, asking the state to be trustee, basically said the state has all the rights and powers of this name, because the state is the trustee. So when you go in there and you think you're Brandon Alexander Adams, you're having an identity crisis, because it's the state that's Brandon Alexander Adams.
It's the plantation's property description, and it belongs to the plantation. Doesn't belong to you. So if you're looking at the Patriot Redemption Manual, there is some errors in there, because they're going to tell you in there what you need to do is go copyright that name. Excuse me. You don't have the rights to that name unless you're going to do something to gain that trust back, because the trustee, the United States, has the rights to that name. So the biggest problem you're going to have if you copyright that name and try to charge the state for using that name on documents, they're going to come after you, because you're a claim jumper. It's their claim, not yours. So you don't want to do that. They've got the first name, the middle name, and the last name. That's copyrighted. But see, under the common law, that's not even your name in the common law. In the common law, dealing with the first, middle, and last, what is your name under the common law? First and middle. That's it. The last name is not part of your name under the common law. So what the state is copyrighting is they're copyrighting what you think is you, but it's not you. If you went back to using just your first and middle name, they haven't got a copyright on that. And if you go into court and they say, are you Leslie Jack Smith? I would never testify and say, no, I'm just Leslie Jack. But if I did that, they can't recognize a Leslie Jack because it's not registered. But they can recognize a Leslie Jack Smith. Now, how many people in here have filed a UCC-1 to try to get their own identity? There's some of you, okay? Have the rest of you heard of that or not even heard of it? How many have not even ever heard of doing that? Okay, there's a number of people in here, okay? Remember, the UCC is where you're filing private claims. And if you're trying to get your freedom and liberty back, whatever that means, there's a lot of patriots out there that are going down and filing UCC 1 as the first part of their process on what generally is called redemption. And in order to file a UCC 1, you got to have a debtor and you got to have a creditor. And they use the name debtor, Leslie Jack Smith, all caps. And then they try to use the name creditor, Leslie Jack Smith, upper and lower case. But in their system, every name is all uppercase. So even if you did that on your app, when anything comes back from the Secretary of State, they're going to look the same. They're all caps. Because caps are fictions, dead things, which is what a person is. It's a dead thing.
Which is what anything in commerce is.
Because it's Admiralty commerce.
Anything with a unique identifier, a name, a title, is a fiction. So in their world, or this world, every fiction is an all uppercase appellation.
Because that's the names on the backs of ships going to sea, vessels. They're all feminine. Admiralty's feminine, and it's all caps, whereas masculine or law of the land is proper upper and lower case. So all your name is a registered vessel in commerce operated under Admiralty Maritime. So it's all uppercase. So how do you get around that? Well, if you were to put in on the fiction or the debtor Leslie Jack Smith, but under the creditor you were putting in Leslie Jack, they got a box for a suffix, don't they? Put of. And then the last name, Smith, starts with a little s, M-I-T-H. Leslie Jack of Smith, is that the same copyright name as Leslie Jack Smith? No, it's different. They don't recognize it in their system as being the same name. So therefore, you know, if you try using the way most patriots do to begin with, and just upper and lower case the creditor name, the Secretary of State many times will write back and say, you can't contract with yourself, this is an invalid filing, hasta la vista, we're not going to file it. And many of them don't get filed. But there's ways around it by understanding what is what and what is proper. And they get it done.
And what names you want to have your interests in. We call this the name game. A lot of our clients get caught up in the name game. And oftentimes it becomes the biggest obstacle to getting any kind of a remedy or result for people.
First thing the judge does when you go into court on a criminal case is, what is your name? Sir, what is your name? Are you, if the defendant's name is Leslie Jack Smith, are you Leslie Jack Smith? And as soon as you say, here and present, Your Honor, you're the debtor, you just screwed up the whole case. You can't respond to the name. If you become the name, you are the debtor. If you're the debtor, you're not the accommodation party. If you're not the accommodation party, how are you going to win this case? So the judge says, who are you? I'm the accommodation party, Your Honor. May we proceed? Well, are you Leslie Jack Smith? Your Honor, I told you I conditionally accept your offer to qualify beyond the fact that I am the accommodation party. Is this court maintaining an obstruction of this case, or are we ready to proceed? He asked, who are you? In what capacity are you here? If you give him the name, what capacity are you here when you answer to the name?
Defendant.
You're the debtor. You just lost your case.
Could you do the first name hyphen, middle name, colon?
No, they're going to go that, well, that's a bunch of crap because the last name is still the same as it was before.
That's the quantum way of writing the name. But when the rest of your document is fictionalized, what use is the name in quantum?
Okay.
I have a huge issue with that because I see patriots doing it all over the place, putting their name in quantum. I don't even think they know where it came from. They just saw someone do it, and so they thought, oh, well, that means the living man. No. It's still a fiction. It's just because it's a noun, you compound a noun with a hyphen. So, Brandon Alexander. Brandon hyphen Alexander is one thing. Just like he was saying, Jack Leslie. It's one thing. The colon signifies of the Smiths, or of the family Smith. That's what the colon means. That's what the symbol, the colon, means. Example, of, as. Okay? So that's why the name is written that way. It's a proper way to create that noun. And a noun is a no. If you look at the word noun, it's N-O-U-N, which is a no, and then un is no. So it's a no-no. What happens if you have two negatives? It's a positive. It's a thing. A noun exists. It's real. Okay, now we're not going to go too deep into quantum, because the place where quantum language falls apart is the maxims of law. Maxims of law state that the intention is the soul of the instrument. The intention is the soul of the instrument. So the fact that none of us know how to properly write or speak English is immaterial and irrelevant. The intention is the soul of the instrument.
When you put that name in there, like in quantum or in reality, in their courts, they can't see anything living, so you're not there. So it's a failure to appear. They can only deal with the fictions. So when we're coming in there as the accommodating party, that's why they will not want to talk and respond to us, because we are the accommodating party. The only reason we can get by with being the accommodation party is because we're probably the only one there that truly has a claim. And they cannot prevent a claimant from being there as long as you do it colorably enough to be able to make it work. See, they summonsed up. Remember, summons, isn't that something you do like when you go to a seance? And if you're going to summon something up, are you looking for reality, or are you looking for something that already died to come back and do something? So when they put out a summons for your straw man, isn't your straw man dead? And so they want him to reappear at the hearing to help them screw up the estate of the straw man. So they're really calling a seance in their dead courts to have the appearance that something real is showing up, when we're not going to deal with him anyway, because since he's dead, every court is a probate court, and who the hell's going to take any testimony off of the dead? You'd be insane to do it. That's why you can't win in the court when you do appear as the dead thing, because you are dead. It boggles your mind to believe that they can get away with the insanity and the crap on us, and we don't even question what the hell is going on. So just take it from us, you cannot win by answering to the name, no matter in what capacity it's in. All you want to do is appear as the accommodation party, and if they intend to deny you, then counterclaim them for obstructing justice and denying justice and equal opportunity. Because if you are a registered accommodation party with a registered interest, they cannot ignore you.
Then if you state to the judge that, introduce yourself as accommodation party Leslie Jack Smith for the defendant Leslie Jack Smith.
I'm not an accommodation party for him. I'm accommodating his account.
Okay, so
otherwise they'll assume I'm representing him.
Remember what the accommodation party stepped into? Trustee of what?
Settling the account.
I thought this is the latest thing that Gordon was saying, but then he's not here to defend that.
Right. Well, it's not the accommodating party for
the defendant.
Okay.
You could be accommodating the account. You could even be accommodating the paramount security interest holder. You see?
Remember what Brandon said. The soul of whatever it is you're doing is the object of what you're trying to achieve. What did we put into that trust that's trying to settle this debt? We set the debt account in there. And so the trustee is there for the purpose of settling the debt account. The trustee is not impersonating the trust name. He's trying to settle all of the matters associated with the trust name, which includes this debt. And he had to step in place of the old trustee, which was the name, because he wasn't doing the job. So he is in place thereof, but his job is to accommodate the debt, which is the object of the trust, settle that debt. And remember, the public is military courts, right? And what does the judge or the tribunal on the military court, when somebody appears before the court, what are they most interested in? The rank of the party there. Hi, I'm general. Hi, I'm private. You know, well, who are you? Oh, I'm private. No, I'm accommodation party. That's who I am today. Who am I addressing? She's just there to tell them who you are, or what capacity you're there, so that you can handle the business. They try to trap you into answering for the name. Aha! You are that thing that's in our inventory. Now you're the dead defendant, because that's the thing in their inventory, and you took on the trappings of the name. So the name game is what they trap you into to get you to acknowledge you're the debtor defendant with no remedy, and now you go sit over in the corner, in the dunce corner with the cap, and we'll settle your problems and tell you how many years you got to go to jail. That's the way that's going to go if you play that game.
And so you're accommodating the account, and if you're accommodating for anyone, it's for the paramount security interest holder, because the paramount security interest holder is the one with what? He's got he's got the claim. He's got the claim to all the defendant's property. So it's only the paramount security interest holder who can settle the debt, because it's only the paramount security interest holder who can say, yes, use this property to set off this debt. The debtor doesn't have any right to use the property. You see?
Well, the question standing anyway. The question standing.
The only question standing if you haven't established any, which you do through not only your private process, but through your public process as well, which we'll talk a little more about today or tomorrow or the next day, because you not only have to perfect, and we're going to go through what we call an A, B, C, 3 processes. An A process, a B process, and a C process. The C process is in the public court. And so there's a standing, but how you enter the case is what establishes your standing. So what have you filed? And in what capacity has it been filed?
Well, if you don't file anything,
then you're going to have a hard time getting your remedy.
you don't have any standing.
Well, no, unless you're the defendant.
Yeah.
Because the only people who have standing are the people who have an interest in the account.
That's
the only people with an
plaintiff
interest
and the
in the account.
defendant, but the